You have to issue notice there.
And also, he will notice maybe, so I will get the answer. He will provide all the relevant document before this court. He will not supplying to us, but he will. We're making communication. He will give all the relevant documents. So some agreements were there. The vehicle was already
Now he got arrested in Connect.
Yes.
Have you filed any bail in that connection? Bail
Bail
petition?
application is filed. I think he's got in the lower court. He's already been allowed on bail.
He is on bail.
He's on bail.
Achha. Okay. What is going on? Still, if it's still under investigation, we can call for the case diary.
Yes.
Otherwise, we won't. Have you produced all these documents? What you have
All
mentioned?
relevant documents will be
You have produced before the IO? City court. And issue notice. So we are issuing notice and we calling for the case diary. If you have already produced before the IO, then it may be there in the case diary.
To support this petition, he has to file some other documents because he pleaded not annexing. He will additional affidavit may be permitted.
No, but before IO, what you have submitted?
He submitted all the relevant documents which has been pleaded in
Now here you want to submit more documents.
more documents.
Okay. And considering you have submitted by the petitioner by bill file their additional affidavit. This yes, whatever. Can we give a date because CD is calling?
After 3 weeks, well,
After 3 weeks, any date?
Not
3 weeks.
on 26th of September 26.
26, 7,
26 9 mal.
26.
9. Keep it right, so
Okay. By that time, you file your additional affidavit also.
I will file.
May I please, your lordship?
26.
May I please, there is heavy traffic, my lord. Item 1, my lord, I missed. Today, my lord, from that side, kindly, item 1, my lord. Already 50 days behind the bar, my lord. 60 days in the mandatory period, my lord.
This case, Kotakurani, I think.
There is heavy traffic.
This is 3.
Yes.
He is done it. Okay, we'll say 1 point.
My lord, page 8 FIR, my lord. He has been shown arrested in this case, my lord. In main case, he already granted bail, my lord. Main case to paper. FIR is of April, my lord. In the main case, he has been, he already granted bail, my lord, in BA number 2097. Later on, he was shown arrested in this case. And already, my lord, 50 days behind the bar, my lord. 60 days, my lord, is the mandatory period in this case, under 392. So, only the period of detention now, the question, only that much, my lord. Nothing else.
He was shown arrest on?
Shown arrested on, my lord. I have forwarding the next, my lord. My lord, dated 11/6, my lord. 11/6. Main case was, my lord, BA 2097. Already granted bail. Only detention now, nothing left, my lord.
What was the earlier case number?
2097/24. BA.
No, not BA.
BA, my lord.
In which case he was earlier got arrested?
2097/2024.
This is the BA number.
BA number.
I am not on BA number.
My PS case number. Morigao, Jagi Road, 95, 2024. Jagi Road, 95, 2024. Jagi Road, 95, 2024.
My lord, here this case is of Nagaon PS case number, my lord. An incident occurred on 26/24 at around 10 p.m. My lord. My lord, highway, my lord, theft of my lord, all these articles. So it may not be मतलब 60 days from 26/4/24 around 10 p.m. Highway 392 then part 2
10 years. May makes 10.
Yes, otherwise from highway only.
highway मतलब this this offense also मतलब occurred on the highway
Highway.
highway.
That's why I have changed.
Kindly see forwarding page 14. Nagaon PS 370 to
highway
24.
between sunset and sunrise and the imprisonment exercise so मतलब 90 days offense from the contents of the FIR.
Contents they have not registered under that section. Forwarding similar. Nagaon PS 370 to 24 under section 392 IPC. Let's see that.
Art study Sharma Design and Consultation. Art we want to design acquisition PP every month we have a state respondent. It's an application section connection with Switch. It is submitted by Mr. Sharma that the shown as in connection with this case and he requested is 11/6/2024. That he is behind a person's last 50 days and hence also his elected position will be under. He further submitted that he was arrested in connection with Jagiroad PS case number 95 of 2010, wherein he already enlarged on bail in 97 of 2010. He further submitted that he has been seized from the person of the then accused person and he was shown arrest in connection. He is ready and reported for the investigation case if it is granted privilege. Mr. Porter put in an additional brief submitted that the earlier the present case is from Nagaon PS and the earlier case was from Jagiroad PS. Further, he submitted that on the conference of the incident had occurred in the highway. Would stop happening is that the case is based on section 392 of the Act. Considering the submission made by the council and without going by the marital details and only on the length of detention. Here it is Nagaon City.
Yes.
Nagaon.
To the certificate of Nagaon City. Okay, done.
Obliged.
You are not saying that
Sorry, my lord. This time is.
you were prayed for adjournment.
Yes, my lord.
Oh, you have not said.
Sorry.
We thought that both all these items has to be taken together. We marked it.
No, my lord.
You want adjournment here?
Then, my lord.
Why?
My Angus council is not available, so.
Who is the Angus council? Italy.
Titeli and Kishom.
And Tisom.
Yes.
Who is it?
Both are not available.
Come back.
And the request
मतलब CD available in all the cases.
Yes. CDs are available.
CD available.
For a week, my lord. For a week.
Not able to be told. Submitted prayed adjournment stating the Angus council not available in this way. So, however, in the Mr. Bott submitted the receipt is already received. In all cases, are you on interim?
Yes. Yes.
Interim, my lord.
In all cases.
All cases. On 6/8 my lord.
6/8.
6/8 my lord.
CDB detail for 6/8 item number 28. That's 31, 32, and 34. Huh? Oh, 31 is 31. There are different councils.
Kishom.
in 32, 34, P Som is there. In 20, P Tele is there. 31, some other concept. Here, for victim also, someone is there.
Yes, ma'am.
But 31 is connected with 32, I think.
Yes.
But these the land counted for in 31. There are 3 councils.
Three
They have
councils.
been not been informed, I think.
Udipta Hajarika.
Huh?
Udipta Hajarika.
Ah. Here the D Gogoi, Arpara, and one part of that. For 2 years, can it be adjourned or what?
Then, my lord, you will also make it item number 31. Then let my lord other advocates come at the time of calling.
See what?
Otherwise, all our tag matters, my lord. You will also want 6-8, my lord.
6, 6. Now see, in all these matters, we have received the case diary in fact. So it will be detained and 6-8 is fixed.
Goodly of that.
Lordship, the matter may pass over for the timing. In this matter, we have filed an additional affidavit.
Time.
May I please, the Lord?
Yes.
Hello, it's a pre-arrest bail application, my lord, and your lordship will kindly come to page 13 is the FIR, my lord. That here allegation is that, my lord, some individuals, my lord, they are making attempt to, my lord, obtain, my lord, permission for birth certificate, man. So that is delayed birth certificate. That is, in fact, my lord, one certificate that is immediately, my lord, applied for, my lord, after birth of any child, my lord, and it is some subsequent point of time, my lord. I am reading, my lord. With reference to the subject cited above, I have the honor to inform you regarding a matter of great concern that has recently come to my attention. It has been brought to my notice that individuals within our district have been submitting fake or false certificates in an attempt to obtain permission for delayed birth certificates. So it is an attempt. In fact, I am not named in the FIR also. In this regard, an inquiry was conducted and the report along with the relevant information is attached, which provides detailed information on the online application submitted, attached documents and the applicants involved. According to the evidence gathered, these false documents include fake medical certificates and non-availability certificate form 10 in the name of, these are the, my lord, office where from, my lord, this is issued, my lord, in the name of so and so state dispensary and so and so BPA health center. Fake school certificate issued in the name of so and so MB school. The submission of such documents is a serious offense. Moreover, so and so CHC has issued both medical certificate and form 10 mentioning proper date and serial number, but without keeping any official records, thereby fooling the administration. So this is, my lord, accordingly prayed for, my lord, for an investigation, my lord. So your lordship will kindly come the accused who are, my lord, named in this FIR, my lord. That is at page 11. Page 11, my lord, at serial number 7, my lord. Your lordship will see that one Dr. Sitto Ranjan, my lord, Haldar, he is the, my lord, officials of Lahorighat BPHC. Next to, my lord, Mr. Abdul Jabbar, Mr. Abdul Jabbar Chaudhary, he is the, my lord, school teacher, headmaster, my lord. Then third, my lord, some Dr. Ahmed, my lord, he is also, my lord, of state dispensary. So these are the, my lord, accused person suspected, my lord, from their office. This, my lord, some certificates are being issued, my lord. Here, my lord, the petitioner, my lord, he approached one person, my lord, for, my lord, obtaining this, my lord, permission of delayed birth certificate. So he, my lord, got it downloaded from one, my lord, his, my lord, known CSP. And, my lord, that CSP owner has been, my lord, arrested on the my lord, suspicion that he might be, my lord, using his CSP to upload any such document, my lord. In fact, when, my lord, he was arrested, then your lordship will kindly come to page 15. This is the, my lord, order by the my lord learned court below, how whereby he was granted bail, my lord. Your lordship will kindly page 15, my lord. I am reading, my lord. Heard learned counsel for bail petitioner. It is submitted by the learned counsel for the bail petitioner that the alleged to be fake document is not fake document, as the register of birth and death Lahorigarh PhD has itself stated by the letter number so and so, and hence prayed for allowing the accused person to. In fact, my lord, this is clarified by the, my lord, from the office of the, my lord, date and birth of that particular my lord, district office, my lord, that this is in fact not forged, my lord. So this is a genuine document. So in that view of the matter, my lord, you also will
At
kindly,
least a CD may be called for, my lord.
and
These are serious offenses, my lord. Only CD
no,
will
in
reveal
fact, my
everything,
lord, your lordship will see, I am apprehending because my certificate was downloaded from this CSP. So in fact,
For the case.
I may be protected because I am the genuine applicant, my lord, and not, I am nothing to. In fact, it's not that, my lord. During verification, my certificate, some,
Try to get this.
yes,
Yes.
it's
On-
not that, my lord. During verification, my any document was found, my lord, my lord, forged. It's
on
not
9-8,
that, my lord.
9-8.
But
You
may, my
will
lord,
not be under interim protection. Case is fixed on 9.
diplomat.
Let's see.
May please your lordship. My lord is a 482 under the Suraksha Sanhita to 2023 for anticipatory bail. My lord, though 302 is there, charge sheet is filed. My lord, I pray, my lord, I will surrender before the trial court and they will consider, my lord. Today is the date and the next date, my lord, today will take time and next date will approach the trial court and court will consider the case.
Case record, can copy of the case record along with case report. But it has to come from where?
My lord, South Salmara. So, my lord, I will surrender before the trial court, my lord. And they will consider, because otherwise, my lord, because in a case we will not cannot prepare an interim order. We will approach the trial court because charge sheet is filed. I have annexed
Shown absconder in the chart.
my lord.
Why? Why you have shown
My lord,
absconder?
because during investigation I was there, a lot of persons' names are there, my lord, but few names are shown, my lord. Few names are shown. So your lordship may look into
Reason why you have not surrendered before the
that. I am surrender before in the. Your lordship may look into page 18, where your lordship will find page 18, last portion. On the other hand, other accused person named such and such have gone into hiding in other states since the registration of the case, and therefore they could not be arrested. That was the reason given.
This is the reason given by the IO.
IO,
You are now could not be arrested.
No, we will surrender before them. We are saying that we will surrender before
It's
the.
your plea. Why the police? Whether police was searching for you, you were absconding at that time. What is your plea? That's what I'm asking.
Malad, we are there before the present place. The police could not found us. They could not arrest us. Otherwise, why we are surrendering before the trial court, Malad? It is their statement that we have fled away. We are there before the in the place itself, Malad. That is why we are surrendering before the trial court, Malad. We are petty businessmen of dry fish.
Let him appear before the trial court. Trial court will consider in accordance with law, man.
That much will do.
And also Mr. report that will be appearing on behalf of government. This submitted by Mr. Chodroy that the present accused petition and involved in bail bonds. However, the case has already been charged against charged it by number 10. Your CS number, can you tell us where is CS number?
278.
Anyway, PRC is registered, no?
Malad?
PRC case is registered.
Malad.
And already been charged. And according to the PRC case number 1493 of 2023, corresponding APR case number 917/2019 has already been registered, showing the present accused petitioner as an account. The party submitted that the accused petitioner is ready and willing to appear before the Janet trial court today and will face the trial. If he is allowed to go on, if he is extended the privilege of hearing. Next part, Mr. Bottom submitted that is not the case. The present accused petitioner is shown as an account in the charge, and without going by the district court, it is not. It will not be proper to submit anything. However, he submitted that the petitioner may be granted, may be directed to appear before the London Trial Court will with an appropriate copy. Next, considering this submission made by the London Council to discuss the gravity of the offence and all the other aspects of the case, I do not find it proper to pass any order on interim protection. However, the petitioner is hereby directed to appear before the London Trial Court with an appropriate copy, which may be considered according with above consideration. Yes. So you are directed to appear before the London Trial Court will
My lord,
with an appropriate
if your lordship, with folded hands, I'm praying, my lord, that portion, if your lordship says that with no interim protection is given, that may influence the effect.
And we'll
That has to be.
okay. We'll remove it.
Okay.
May I please?
Yes.
My lord, this is for 38 application, my lord. FIR is at page number 14. Allegation is under section 447, 341, 354, 376, 511, my lord. So far as the FIR, my lord, there is no any elements of section 376, and at the same time, my lord, all this act is impossible. For committing all this act at a one time, my lord, impossible, my lord. Moreover, my lord, LS incident occurred on 4/6/24, FIR lost on 19/6/2024, my lord. 15 days delays without explaining any reason, my lord. So, my lord, I may be protected, my lord. By this time, CD may be called for, my lord. No ingredients of section 376 available. We have also filed FIR against the brother-in-law of the informant, my lord. Page number 7, my lord. Page number, my lord, 9. There are going some dispute between both the families, my lord. So, my lord, CD may be called for by this time and may be protected.
This is an attempt, my lord. Otherwise, 164 statement will be required. At that point of time, her mother
CD along with 164, my lord.
Heard Mr. A. Padamani, London Council for the petition, and also heard Mr. P. Waterford, the London petition to be appearing on behalf of state respondent. This is an application section so and so in connection with so and so. Mr. Paramani, the London Council for the petitioner, submitted that this is a false and concocted allegation brought against the present petition. And present petitioner, rather, there was a dispute between the parties for which who lost the other FIR?
My wife.
For which the wife of the petitioner also lost the cross FIR against the present informant, against the husband of the present informant. However, the petitioner is ready and willing to negotiate. Mr. Bott submitted in this regard that the fact of it is, and especially the statement of statement of the victim recorded on section 164 CRPC is necessary. So good. Okay, will be under interim protection.
My
22/8, my lord.
22/8.
Yes.
My
Appear before the IO within 7 days.
highly honest.
May I please, your lordship? 438 application, my lord. My lord, what happened? I take your lordship to page number, FIR, my lord, at page number 15, my lord. Radiant Group is an organization who are managing the cash management service. That is, money is being transferred from one place to another place, my lord. On 25/6/2024 at Kokrajhar, my lord, an amount of 34,51,886 was brought from the LIC office to deposit to the Axis Bank. Immediately by Chief Executive Officer Prasenjit Aich, gunman Rahul Roy, Tuton Borman is the driver of the van, and they were in the vehicle, my lord. And while money was being taken into the room of the Axis Bank, suddenly some hooligans has snatched away the bag. However, the gunman opened fire when Amir Hussain was injured because of the bullet fire. Meanwhile, my lord, all these persons have been arrested, including Chief Executive Officer, gunman, and driver of the van. And now, my lord, I am the petitioner before your lordship, whose van has been given let out to the organization to carry the money. It is a monthly payment basis, my lord. My driver is arrested, my lord. The police searched my house. So out of police is asking us regularly to come to the police station. We are visiting also. But that's why there is an apprehension in our mind that I may be taken into custody. That's why I have come. CD may be called for, my lord. And in the meantime, entire amount has been recovered from all these persons, my lord, including Amir Hussain, my lord, who was injured, and after recovered, he was taken to the custody, my lord.
Have you annexed any document to sub
My driver. That's why I'm praying for CD, my lord. And all this, my lord, recovery slip I have given, my lord, from how much money has been recovered. I have annexed all those things, my lord. All seizure list will reveal that almost entire money is recovered from different person, my lord. And these persons are involved here, my lord, who are arrested, taken into custody, including Amir Hussain, my lord.
yes, sir. Yes.
Only CD at this stage, lordship. To go to the statement of the accused, lordship.
Yes, yes.
Let us call for the CD at this
Lordship.
protest. So we are calling for CD at this stage.
Yes, yes. Kokrajhar.
Okay.
My lord, date may be given.
Lordship. 12.
12th of August.
Developed.
Not please, Lordship. The allegation is serious one, Lordship, but I just want to point out the circumstances, Lordship, why it happened, Lordship. Lordship, we kindly turn to page 11, Lordship, the FIR.
Yes.
But with due respect, the humble submission is that on 30/6/2024 at about 11:30 a.m., by taking advantage of my absence at home, someone coming in a white color four-wheeler vehicle forcefully kidnapped my daughter, Sri Jupiter Thakuria, from my house. One Sri Anil Ujir, son of so-and-so, is being suspected regarding the matter because some days ago also said Sri Anil Ujir has kidnapped my said daughter. This is a present petitioner, Lordship. Lordship, we kindly turn to earlier FIR, Lordship, that on page 16, Lordship, that page 25/4/2024, page 16. This is the FIR. With due respect, the humble submission is that on so and so, my daughter Jupiter Thakuria went missing while I was alone at home, and on the same day, I submitted an information to Swalgosi police. Yes, regarding missing of my daughter, but in meantime, it has come to know my daughter has been kidnapped by accused number 1. The present petitioner has been named with the help of accused number 2 and 3, kept her concern in unknown place. But this is the FIR dated 25/4/2024, month of April, Lordship. Regarding same incident, Lordship will kindly turn to page 21. This is the forwarding report, Lordship, that he was arrested on 29/4/2024 in connection with earlier FIR, Lordship. This is the forwarding report, and Lordship will kindly. Huh? Thereafter, Lordship will kindly turn to page. No, no, page 33, Lordship. Page 33 and 32, kindly turn to page 32, Lordship. This is the order, Lordship, when the victim girl was recovered, Lordship, in connection to earlier case, Lordship. The page 32. And operative portion on page 33, Lordship, the middle paragraph, Lordship. 33, Lordship. The victim girl has stated, Lordship, the victim girl has stated that his age is 17 years and hence is a minor. Upon being asked, the victim is not ready to go with her parents, Lordship. These are circumstances, Lordship, at the earlier case. And thereafter, Lordship, matter was charge sheeted, Lordship. Someone is there. The matter is, the earlier case is already been charge sheeted, Lordship. Now, Lordship will kindly turn to page 6 of my petition, Lordship. Page 6, paragraph 10 of my petition, Lordship. Paragraph. The petitioner begs to state that in the meantime, the said girl was taken as she as a minor and she was refused to go back to with her parents. Lordship, she was sent to CWC, Lordship, Child Welfare Committee, Lordship. Lordship will kindly see. In the meantime, the said girl was taken in custody by her parents from CWC, but they could not keep her with them at home, and the girl again eluded from home on 30/6/2024, the date of FIR, Lordship, and went to the petitioner. Although the petitioner asked her to go home, but she refused to go back and also threatened to commit suicide if he is sent back to her home this time. And this is the compelling situation. This is the situation why, Lordship, the petitioner has taken the escape, Lordship. I'll produce the victim before the police, Lordship, if Lordship grant the interim, Lordship. This is a purely a case of love affair, Lordship. It's not a case of, Lordship, kidnapping. The earlier case also proved that, Lordship, that the girl, even she did not want to go back to her parents, Lordship. Under this such complaint situation, Lordship, we have taken this step.
No, but here in present case, where she has already been recovered.
No recover. She is with me, Lordship. Only the thing is that if I granted interim, I appear her before the IO, Lordship, for recording her statement.
One case, Lordship, is pending against for kidnapping. Again, he's finding the same thing.
So he's proved that it is a case of love affair, Lordship. It's not a case of any kidnapping or ransom and that thing, Lordship. But the girl is also, Lordship, she is much more involved, Lordship. That is why the statement made before the magistrate, Lordship, at the time of recovery, that she don't want to go with her parents. She was sent to CWC.
Let him appear and record the statement of the victim, Lordship, 164. It will shed light, Lordship. Victim statement, Lordship, if she appears.
Now we are running here and there, Lordship. If we get the interim, Lordship, then we can produce the girl, Lordship.
He says the girl is with him.
Yes.
It is an admitted fact, Lordship. I'm not
If
going
he's
to.
allowed to appear, Lordship, then maybe the statement of the victim can be recorded, Lordship. Apparently, Lordship, appears to be a...
The General Counsel for the petitioner, Mr. D. Sharma, this is an application on certain it is submitted by Mr. Pune that the petitioner is and innocent. However, it is a fact that in the earlier occasion she loved with him, and for that reason only one FIR was earlier filed. by on their file on 29/4/2024, where the present petitioner was arrested, and subsequently the case was charged sheeted. But from it is further submitted that from the order passed by the London Chief that after recording her statement of Section 1 of PRPC, she was she refused to go with her parents, and for which reason the London Magistrate had to pass an order, and the girl was in custody of CWC. But again from but CWC, he further submitted that from CWC the parents took Jima of the girl, but she again eloped with the boy and pressurized the petition not to send her home, otherwise it would commit. However, if the petitioner is granted the interim protection, he may produce the victim before the eye to record her statement as as he could not appear before the eye due to apprehension of being arrested in connection with this case. Mr. Sharma submitted that apparently if that the case was love affair, but considering the statement recorded statement, her statement is necessary. Her statement is required to be recorded under Section 1. However, Mr. Sharma submitted that the one chance may be given to accused petitioner to cooperate the eye in further investigation of this case. Next part. Considering the entire submission made by funding of the purposes and other aspects. Okay, you'll be under interim protection.
22nd August.
22nd of August. Appear before the eye.
Lodge. Even I will produce the victim also. Much obliged, your Lord. Much obliged.
May I please also? Item number 9 and 10 you will also arising out of the same affair. You will also. Lordship may kindly take up item number 10 first.
What I'm saying,
Item number 9 and 10 you will also arising out of the same affair.
Same affair, acha.
Yes, sir. Lordship may kindly take up item number 10 first.
10 first. 10.
May I please also?
Yes.
These two persons here also, the petitioners are the employees of a company here also called GDCL here also. Engage in construction of your roads here also. Lordship will find, and they are also the your lordship authorized persons of the company. So lordship will find the authority letter your lordship. Annexure A, page 15 your lordship. Lordship, got it? Number 2 you also Ankur Setia. Petition number 2 your lordship. And number 3 Devasis Buragoy. Petition number 1 your lordship. Now your lordship will find the FIR at your lordship annexure C, page 21 your lordship. Operative part your lordship starts from your lordship page 24. May I read your lordship? Subject: 4-laning of Jorhat to Janji section NS 37, unauthorized access and illegal theft of the machinery lying in the highway land near Dihapul in Jorhat district by a group of people. Information and necessary action for unlawful activities, theft, and creating unsafe condition on highway RG. Sir, this is to bring to your attention that a highway machine paver of MSGDCL has been lying since 2021 highway land. It is your lordship, the machine is of the GDCL lordship, from which the petitioners are the authorized persons and employees of the company, your lordship. at Dihapul, although the contract with MS-GDCL was foreclosed on 30/10/2021, MS-GDCL was allowed to demobilize after 30/10/2021 within 15 days and vacate the site. One piece of machinery was kept lying at the location mentioned above unauthorizedly as any use of highway land without written permission and payment of rent under the control of land and traffic, National Highway Act 2002 and Highway Administration Rules 2003 is illegal. On 10/7/2024, some unusual movements were noticed at the above said locations with ROW. It was noticed that two giant hydraulic cranes, one trailer, and a group of 5-6 people were lifting the highway machine lying at Dihapul. While lifting was done, the traffic on the highway was obstructed and unsafe conditions on the highway near Dihapul were created. As a highway administrator, the undersigned informed Bosi Tiok, IC Ladogor, and CO Tiok about the incident and the illegal theft activity. That cannot be theft, Your Lordship. They were the company persons they were shifting the Your Lordship machine from Your Lordship roadside to their camp nearby. Also, it is 2.5 kilometers away. It is called Melang Metal, Your Lordship. It was witnessed by the police officials on spot in presence of undersigned and Mr. Prasanto Bora, Mr. Devasis, petition number 1, Your Lordship, Mr. Pritom, along with others, in a group of 5-6 under a planned way, hired the trailer and hydraulic cranes and were stealing the machinery in daylight from highway land by accessing the highway illegally, creating unsafe conditions on the highway. The details of the trailer and hydraulic cranes were not noted by police officials and statements were recorded on the spot. All 5-6 people fled from the place. However, the photographs of these people were before fleeing were taken and are attached herewith. This is to inform you that MS-GDCL has been served with a notice to pay the rent of rupees 5 lakh and vacate the site immediately. The NSADCL authority, they himself directed to vacate, Your Lordship. That is why we were shifting it from Your Lordship from roadside to our camp, which is at 2.5 kilometers away. Also. So in my humble submission, Your Lordship, section 111 and Your Lordship 303 is not attracted against the petitioners, Your Lordship. And Your Lordship may kindly see why the petitioners why the company were late in Your Lordship lifting the machine from the site, Your Lordship, because the obstructions made by the Your Lordship, some local people, Your Lordship. That is why the company, even Your Lordship, had to approach this honorable court. Your Lordship will find that that order of this honorable court, Your Lordship, at Annexa B, page 18, Your Lordship. They had approached the police, Your Lordship, district administration. They were not helping, Your Lordship. That is why they had to approach this honorable court, Your Lordship. Although thereafter, Your Lordship, after some of the machines were shifted, Your Lordship, but the paper machine was lying there, and as per the notice of the Your Lordship judicial NSADCL authority, they were just shifting it, Your Lordship. That is why, Your Lordship, section 111, which is Your Lordship organized crime, and 303 theft, Your Lordship, is, in my humble and respectful submission, Your Lordship, not attracted against the petitioners, Your Lordship.
But the person who lost the FIR is the general manager.
He is a general manager.
So that means it should, or this thing should be within his knowledge
Lordship.
regarding it.
Lordship.
If he is the general manager,
Lordship.
that NSDCL has asked you to vacate the land or asking for the rent and etc. For the prison, if they are shifting, that should be within the knowledge of the manager only. So why he has lost the FIR?
Lordship, that is the mystery of Lordship. Why they have lost the FIR? Yes, Your Lordship. Why they have lost the FIR? It is the second Your Lordship, second one, Your Lordship. Because Your Lordship, like I see, the condition of the route from Jorhat to Janji is very devastating, Your Lordship. Because of the devastating condition, Your Lordship, for last 10 years it is not completed, Your Lordship, because of the anomalies committed by contractors and also the NSADCL authorities, Your Lordship. That is why here the petitioner, Your Lordship, may kindly take up this one. Item, Your Lordship, 9.
No, but why you have acted?
They have, Your Lordship, what they approached, Your Lordship, the district magistrate for your magisterial inquiry, Your Lordship. And next day, before filing of the present FIR, also, what has happened? A 2.5 years old boy, Your Lordship, died lying in a pit in a national highway, Your Lordship. And this petitioner, Your Lordship, lost, Your Lordship, FIR against the Your Lordship NSADCL authority for Your Lordship committing this crime, Your Lordship. And As a result of that, Your Lordship, the NSADCL authority, more particularly this general manager, Your Lordship, he is named in the earlier FIR, Your Lordship. This lost this Your Lordship FIR against this petitioner and these 3 persons, Your Lordship.
And your two petitioners are the authorized person of which company?
Lordship, NSIDCL, sorry, Your Lordship, GDCL, Lordship, Ganon Dangle, the machine owned by that company, Your Lordship. Lordship, I could not annex the Your Lordship appointment letters of the petitioners, Your Lordship. Lordship, kindly release the appointment letter. They are in fact the camp in charge of the Your Lordship GDCL, Your Lordship.
Lordship, a salt date may be fixed for calling the CD Lordship. Even next week also, Lordship. CD.
Next week.
Next week.
Lordship, may kindly see, in my humble and respectful submission, section 303 theft, it is not your attracted, Your Lordship. Not to speak about section 11, Your Lordship, it is organized crime. How it can be organized crime, Your Lordship? We are shifting our machineries to our camp, Your Lordship. That means broad daylight, Your Lordship. If we are going to commit theft, whether we are going to commit theft in the broad daylight, Your Lordship,
That is obvious.
that is, Your Lordship. In the national highway, Your Lordship, itself.
Mr. UK Decca,
You can take a look.
number does to had Mr. UK Decca, the council for the petition, and also had Mr. Sharma, the land additional PP, everyone about state on it's an sorry. It is submitted by Mr. Decca, the land council for the petitions that these two petitioners are they are not involved in any offense as alleged in the affair. Both the petitioners are the authorized persons from Ganon Edward Danke related. Ganon so and so company and as the NHDCL and as the NHDCL asked to vacate the premises and the asked to pay the rent, the present accused petitioners, being the authorized person of the company, was shifted the machineries from the roadside to their camp in the broad daylight in the daytime. But as there was earlier an FIR against the present informant after death of the child who died after death of a child, the present the present FIR has been launched against some of the officials of the company with some false information. He further submitted that the case is not affected against the present petition under section 303 of section 62 111 of the PNS 2023. However, all these petitioners, being the responsible person, are ready and willing to cooperate the IO in further investigation of this case if they are granted with the privilege of the case. Mr. Sharma submitted in this regard that CDP revealed the fact of the case as to whether the machinery etc. were revealed the actual fact of the case, and accordingly he insisted to call for the case. Next para, hearing the submission made by Learning Council for both states. The documents annexed with the and other aspects of the matter. I find it a bit case to extend it to the petitioners. And what about year 10? We are giving you interim.
Lordship,
What about 9?
he is your lordship. Lordship, kindly see. He is a businessman, your lordship. He has nothing to do with that, your lordship. As because he has lost the FIR, your lordship, will find the FIR annexer C, your lordship, against the your lordship general manager. The general manager. Page 29, your lordship. That case has been registered at TOPS case number 56, 2024, under section
It is, you know,
304.
out of same FIR. It's not out of same FIR.
No, this FIR has been lodged by the petitioner, your lordship, against the general manager, your lordship, NSIDCA.
Same,
That
same
is why
FIR.
Huh?
Same FIR he's taking bail. Lordship.
No, he is a businessman, you're saying?
no, no, no.
If Lordship kindly comes to page 7, Lordship. Page 8, Lordship, sorry. Page 8, paragraph 5.
Page 8, paragraph 5.
Paragraph 5 of this item number 9, Lordship.
The designation is with you are on para, which number para?
Paragraph 5, Lordship.
You are on para 5. Huh?
Page 8.
No, it's not page 8.
Item number 9, Lordship. Prasanto Bora.
I don't know, there may be some
Lordship,
para 5. Para 5 starts with that the petitioner begs to state.
The employees of Messrs. GTCL, namely, Lordship has found. Item 9.
Like,
पेज से मिला नहीं देखियो ये तो पेरेग्राफ লাগিছিল তো বেলেগ বেলেগ পেৰেগ্ৰাফ মূল পেৰেগ্ৰাফ বেলেগ হৈছে পেৰেগ্ৰাফ 7 Paragraph 7, Lordship will see. The employees of GTCL, namely Ankur Sethi and Debashish Buragoy, asked the petitioner whether he is known any person having hydraulic crane as they were in need of the same for shifting of huge paper machine of GTCL lying at so and so. The petitioner is known to one Rajendra Singh of Jorhat, who is the owner of hydraulic crane, and has such requested him over phone to provide his hydraulic. So he is the person who provided.
that is why, your lordship. As per request, your lordship, if that person provided the hydraulic crane to leave the your lordship paper machine to that petitioner. This person, this petitioner has been, your lordship, entangled in this case, your lordship, as because he has lost, your lordship, FI, your lordship, Annexer B, your lordship, against that general manager of the NSADCL, your lordship. Annexer B, page 29, your lordship.
this was lost by him.
Yes, your lordship. The petitioner against, your lordship, that general manager, your lordship, and others, your lordship. And also Annexer 1, your lordship, mechanism, page 16. It is to the district commissioner, your lordship, seeking, your lordship, ministerial inquiry, your lordship, against the anomalies, your lordship. That is why he has been, your lordship, entangled in this case, your lordship, along with others, although he was not present. Your lordship.
মানে সেইটো দিলেতে 29 of the form is to use the data. Again, submitted that he was simply provided a phrase for shifting the paper machine. For shifting the paper machine as on the request made by the officials of the company. But he is entered in this case as he earlier lost an FIR and also asked for judicial inquiry after the death of a child. After the death of a child against the present property. However, he is really বাকীখিনি একেটাই ৰেডিয়েণ্ট উইথ কোঅপাৰেট আৰু মিষ্টাৰ টমাৰো ছাবমিশ্যন দি থাকিব য়েছ when
22nd
22nd of 22
I'm deeply obliged.
appear before the IO and cooperate
Within your also, within 7 days only.
within 7 days.
I'm deeply obliged. May I please, Lordship?
Yung kapuli ko na. Ito, item 10 all over. Item 10 kami.
May I please, Lordship?
Yes.
This is a 482 bail application, my Lordship. Offense under section 147, 148, 149, and 302. I'm on apprehended arrest.
It's a 302 matter.
Yes.
Why are you apprehending it?
My name is
No, see, it is
implicated in FIR.
is it a case of charge sheeted one? No.
No,
No,
no.
Lordship.
CD may be requirement. All for CD, my Lordship.
302 obviously CD will be.
My Lordship, matter may be fixed on 6 with the BA number 2113.
The status BA number
2113 2024.
211324.
Similar FIR, my Lordship. On 6
Six.
Obliged.
List on 6844 for CD along with BA number 2113.
May I please, my lord? The 482 application, my lord. Section is 21A, 27, and 29. Kindly call for case diary, my lord.
CD we call for. Yes, Sharma. When can
Lordship, কিমান দিন?
Thuguri.
Lordship, let it be on 22.
22A
20.
হবে না?
20.
Obliged.
But have you? আমি আমার কাছে দিই স্পেশাল না আমার স্পেশাল একটা কেস আছে মনে yes then
May I please, your lordship? Your lordship, kindly see the FIR 302 matter, my lord. The present petitioner before your lordship is a, my lord, lady, is a government servant. My lord, page 8 is a FIR, my lord. In the FIR, my lord, as many as 7 accused, my lord. I am for 1. On accused number 3, my lord. Page 8, my lord. Basiran Nessa, my lord. He is a government employee, lady, my lord. My lord, what happened, my lord? It's a long affair, my lord. My lord, the parents reside as Guwahati. Her 12-year daughter, during last summer vacation, went to her grandmother's house at Bollur. Mother came from Guwahati to her mother's house. The daughter, victim girl, want to come back with Guwahati with her mother. Mother says, "You should not come with me. Your study will be defect." In this regard, the mother admittedly, her mother imposed 2-3 slap on her back. Mother come out to Guwahati, she committed suicide. This is the fact, my lord. And now present petitioner, my lord. She is, my lord, petitioner's daughter, grandmother, my lord, present petitioner. Petitioner's daughter died, victim, my lord. She is, my lord, presently grandmother, mother-in-law, grandmother, my lord, from maternal side. And my lord, her unfortunately, my lord, her house, my lord, situated at about 4 kilometers distance from the place of occurrence. And on that day, she is on duty. I have annexed, my lord, attendance register also, my lord. My lord,
it's okay whatever but the question is that the case of
302, my lord, that is the problem. My humble submission, my lord. Is a government only protection service may be protected, my lord. If, my lord, any adverse comes in the city, my lord, state may be rejected.
302 become
Direct allegation is
Direct
against the petitioner. Lord.
against all the petitioners direct allegation.
Direct allegation.
My lord, only one line may I read, my lord, in the vernacular person. যোৱা 16/7/2024 তাৰিখে মোৰ স্ত্ৰীয়ে, the informant is the my lord husband, মোৰ স্ত্ৰীয়ে মাকৰ ঘৰৰ পৰা গুৱাহাটীলৈ বুলি ওলোৱাত
মোৰ ছোৱালীও লগত যাব বিচৰাত মোৰ স্ত্ৰী, that is mother of the victim, and 2, 3, 4, 3 is the my lord present petitioner, 4 and 6 পদকীয়ায় বাধা প্রদান করে। My lord, my house is 4 kilometer distance, and at that time, my lord, I am in service, my lord.
Okay, you are calling for the case diary. See now, Manaf, it is a case of 302. Just we need the case diary. Yes, Rama. One can
Lordship.
be-
21 8
My lord, it is a government thought date may be given, my lord. Otherwise, my lord,
16 Lordship.
16-8.
my lord, may I pray, my lord, on first week of August, my lord.
Yeah, no problem.
My lord, he's a government employee, my lord. My lord, his service will be hampered, my lord.
First week of August is this week only, Lordship.
Yes, sir. Yes, yes, my lord.
Lordship, let it be on 9 Lordship. At the most.
9-8. Oh,
Obliged, my lord.
May I please tell you, 438 application, FIR is on page 17. May I read the FIR? Your Lordship, with due respect, I would like to inform you that today on so at about so the headmaster of LP school number so namely Sri Basudev, duly received the relief material goods of Biscuit Village, and after arranging one vehicle, he handed over the same to the accused number 3 and 4 so that they can escort the same to the Biscuit Village. At the time of traveling, the accused number
village.
See-
Name of the village is Biscuit Village.
Biscuit Village, Biscuit,
Name of the village.
Biscuit.
Oh,
3 and 4 stolen the relief materials and kept them in the jungle. But after seeing this, some people of the locality protested the same and shouting. The accused person got angry and used slang language, and also accused number 1. Accused number 1 injured the complainant's father Abdul Hakim with the. For this, his head was badly damaged. They also injured other 3 persons physically. People of the locality then rescued my father from the accused person and sent him to Korimganj Civil Hospital, and his condition was serious and he was referred to Silchar Medical Hospital for further treatment. Now the accused person also threatened us with dire consequences and attempt to murder, and the attempt for murder was made to my father. Here, Lordship, the allegation as regards to assault is very clear. Only one has committed assault on the complainant father, and I am for 3, 4, 5, 6. 3 and 4, the allegation is stolen the relief materials, and accused number 1 and 2 are also in custody. So as regards to assault, there is no allegation regards to 3, 4, 5, 6.
Is there, Lordship? It is clearly said they also injured other 2-3 persons physically. Case of 302, 307. Lordship. Let the CD come, Lordship.
they also.
But here specifically written that accused number 1 injured the complainant father Abdul.
Next line, Lordship. They also injured other 2-3 persons physically.
They only kept the relief materials, and the no FIR from the headmaster. The headmaster who had handed over the relief material to them.
What is case report along with the medical report? If there is nothing against these 3 petitioners, they will get the bill.
Yes, on
We are calling for the case diary.
Lordship.
interim
Along with medical report.
Medical.
Yes, when can be.
Lordship. 14-8.
interim protection, Lordship. There no specific allegation is only
Thereafter, the second, third line, your allegation is there also.
Yes.
14-8 along with the medical report.
14-8. Problem.
May it please, Your Lordship.
Yes.
But this is a peculiar case I have come across. Then, in this method, the learned session judge granted interim order asking the petitioner to appear before the police. He went twice before the police. Ultimately, on last occasion, those 2 days he could not meet the IO. Ultimately,
Okay, the CD of this case is already available in item number 23. So this matter can be taken up at 23 location. We have to go to location. We have received the case very just. Can be
Well,
taken.
if case diary is already available, let them go to his case diary
if
after some time.
case diary may not be necessary, your lordship will kindly listen to me. Then he went there twice. IO did not meet him. So what he did, he took the photographs of the entire police station, came back, filed an affidavit before the learned additional session. But without any reason, session judge refused to make the interim order absolute. So we have come here. May I read that order, madam? 48. Page 65. 63. Page 63 onwards. May I read? This is a petition filed under section 438 of SEL, seeking liberty 2 years bail for the petitioner, is so and so. The learned counsel for the accused petitioner has submitted that in compliance of the order dated 8/7/24, the accused had visited thrice to the police station. However, neither the IO nor the OC could be made, and as such, his statement has not been recorded. In this regard, an additional affidavit is also filed by the petitioner. The learned counsel for the accused petitioner further submits that the accused is innocent and has been falsely implicated in the instant case. It is submitted that the alleged forced cell deed is neither prepared nor issued by the petitioner, and also the petitioner is in no way connected with the said cell deed. It is submitted that the petitioner is ready to cooperate with the investigation. As such, the instant anticipatory bail petition may be allowed. IO Sri Abu Bakr Siddiq has appeared and strongly objected to the instant anticipatory bail petition. He has also filed bail objection. On 16/5/2004, the informant Hiramani Chaudhary, as of so and so, lodged a petition before the Chief Minister Assam, stating that 2014 she had purchased a plot of land for her employees. However, the entire matter was looked after by her unemployed brother. She also stated that she had lodged an FIR at Boshisto PS, but no step was taken till today, and she said land is lying vacant. She also requested to take necessary action against the culprits. It appears that upon receipt of the said petition, Parag Burman was directed to conduct an inquiry and to submit a report. Further appears that accordingly an inquiry was conducted and preliminary inquiry report dated so and so was submitted by the SI Parag Burman, stating inter alia that upon his preliminary he found that Sri Nogen Rangson lost a civil case, and thereupon Simanta Chaudhary, Tapas Chaudhary and his associate approached him and collected documents from him by giving false promise that they will help him in getting back his land. However, instead of prepared a fraudulent sale deed by so and so, it has been shown that Sri Nogen Rangsang had purchased the said land from the Subhakana Agrawal, but Nogen Rangsang stated that their family was a royalty in that land, 1970 and 1980, and they had not purchased the said land. It is also stated in this report that upon examination of Rajiv Seria, younger left Agrawal, it came to light that their family had not sold the said land to Nogen Rangsan. It is stated that as per the decree of the court, the land is with the family of Wakaran, Zits area, Agrawal, by civil case number. It is alleged that the said Simanta Chaudhary, Tapas Chaudhary, and their associates has conspired and sold the said plot of land to Rudraks and a private limited by a fraudulent deed in the name of Nogen Rangsan. It is also stated that Simanta Chaudhary, Tapas Chaudhary and their associates, in connivance with the several government affidavits of Revenue Department, had collected the sale permission mutation record of the said land and later on sold out to Rudraks and Private Limited. Pursuant to the said preliminary report, the instant FIR was registered. It appears from the case diary that the bail objection that on the strength of the forces sale deed in the name of Sri Nagen Rangsan.
So now
The above
it's
no-
not a case that, but the question is that as per you, he visited the police station for 2-3 occasions. But he could not meet the IO and his statement could not be recorded.
Yes.
Accordingly, he took some photographs and
Yes.
those were produced before the court-line court below. But by going by the order, most probably it has discussed in detail by the learned trial court. Not only for that reason, only entire material has been discussed. See, hearing the objection made by the learned additional PP or whatever. So this is the detailed order has been passed after perusal of the CD only, as it appears from here. It's not a case that you tried to appear before the. Your statement could not be recorded by the IO as he was not available. Only that reason your petition is not rejected. Your petition has been rejected discussing the entire detail of the case.
So that's true,
Yes.
but I went to comply with the.
Comply with the record.
But if this is the behavior of the police, then the High Court's order becomes absolutely useless. Now, even now, your Lordship can.
Where is the earlier order prior to this rejection order?
That is also page 48.
48.
Yes. Relevant portion is at page 49. 49 is the relevant portion, last paragraph.
Page 49. The learned counsel for the accused petitioner submits that the interim protection may be granted till arrival of the case diary. Considering the fact that despite repeated calls, no case diary has been received, this court deems fit to grant interim protection to the accused petitioner till the next date of hearing. In the event of the arrest of the person so and so, the accused petitioner shall appear before the IO within 10 days from today, and he shall cooperate in investigation and also shall appear before the court as and when called to do so. The accused petitioner shall not commit any similar offense. The accused petitioner shall not offer any inducement, threat, or promise to any person acquainted with the facts of the case in order to dissuade the person from disclosing those facts to be police duty. So may I submit, my lord? I can again appear with your lordship's order, and your lordship may grant the interim bail. My-
Sharma, because the question is that he was earlier granted bail, but his statement was not recorded.
Not recorded.
Or is available? Or you have to go to
We will
the
have
case
to go
diary.
to the case diary.
No, statement has not been recorded.
Not yet recorded.
No, I am not asking that your lordship will dispose of the matter. Your lordship can go to the case diary. Lordship would kindly give me the interim before reading the case diary. Let my statement be recorded by you. But this cannot be allowed. I filed an affidavit that I had gone there. Your lordship, that affidavit your lordship will find at page 51. With all photographs. With all photographs. Photographs. Page 50 onward. Page 58 onward. 750. 56. Your Lordship can see the photographs of the police station.
Yes, I have seen.
All these pages, 56, 57, 58 to 61. Let police record my version.
Yes, Sharma, anything you
Lordship,
want
since,
for it, you can say. It's up to you.
Lordship, since CD is already available, Lordship, the matter can be finally
No,
disposed of,
CD
Lordship.
will be decided in absence of my statement. Court earlier wanted my statement. Let it be recorded. I am ready.
Lordship, then my submission will be that the interim was granted. Thereafter, CD was perused. Finding materials, the interim was vacated, Lordship. Now, Lordship, since even if he records the statement, Lordship will have to go to the case diary. Ultimately, Lordship. So, in the interest of justice, Lordship, today itself
By
the
that
matter can
time,
be
my
disposed.
statement will come. Give me 10 days time with your Lordship's order. I will appear.
In the interest
What
of
is the
justice,
difficulty?
difficulty is nothing there, Lordship. The judicial propriety, interest of justice, Lordship, the matter can be disposed of today itself, Lordship.
What is the judicial property, Miller? A petty officer, he just picked up the court's order. Your Lordship will kindly read my affidavit. In fact, Miller, in
Yes,
the fitness
I
of
have
things, the
seen the
learned
audio.
public prosecutor should
Because
join
that's
with
what
me.
I'm just asking you. It's not a case that because of his non-appearance, but it is the case wherein on
Yes,
perusal of the case diary only
yes,
it has been rejected.
yes.
In absence of my statement, court wanted to see my statement.
Court wanted to see in your statement means court granted you interim
Interim
petition as because this CD
not
was
available.
not
Repeated calls.
That happens in every case,
before.
my lord.
That's what. That's what.
Why it should be
Yes.
decided expertly?
No, not expired.
Short time may be given, my lord, but this is where the criminal cases are delayed. I'm not asking for a moon. I want to go back to the police again. And your lordship should take a strong view about the behavior of the IO. Public prosecutor was not heard. IO was heard. What is this? I have not seen any case till now, my lord, that IO is heard in a bail petition. Public prosecutor is missing. Your lordship may
Prosecutor was not heard.
your lordship may make it clear. Both sides will be heard, and protection should be granted to me. Meanwhile, I will again come back to this court.
Lordship, again, my submission will be the same, Lordship. Since it is available, Lordship, based on those materials, the court rejected the interim protection, Lordship. Now, based on that materials, Lordship can consider his bail application, Lordship. Finally, Lordship, it can be disposed of, Lordship, instead of.
Meanwhile,
bringing it down,
maybe
Lordship.
I may be arrested again. It will be in Foxwell.
Today itself, Lordship can decide it, Lordship. So, if there are no materials against him, Lordship, it will be in the final bail, Lordship. That will be my submission, Lordship. Instead of giving him interim, Lordship, can give him final bail, Lordship. If there are no materials.
No, no, I want that my statement should be recorded. Court's order should be honored. How many cases your lordship have come across that the accused is paying for going back to the police, that too with this behavior?
Two aspects are there in this case. One is that the court granted him interim.
Lordship,
That is there. But his statement was not recorded.
not recorded.
As he has filed an additional affidavit.
Lordship.
That is there.
So
So
whether, Lordship, that has any relevance to the final outcome of the bail application, because the court, using its application of mine, Lordship, after going to the case diary, have rejected the bail
Is
application.
it not
Lordship.
one-sided then?
Not at all,
Court should apply mine to both sides. Court did not have that opportunity.
and you want to submit it after perusal of the case diary.
Yes, Lordship, with item number 23, Lordship. In a short while, we can do it, Lordship. Or if a senior agrees, Lordship, it can be taken up at 2 also, Lordship. If he has any issues, Lordship. At 2,
But it will be again one-sided.
we'll have both sides. Can it be taken at 2?
2.
Along with
I am appearing for item number 23, my lord.
you are for
We take it
20.
now only.
He wants to torture me. নহয় কি তোমালোকে জানা তো?
So 15 with 23 at 2. At 2. Let them go periodically. To fill here. Otherwise, I have recorded your submission, what you have submitted. But the question is that after perusal of the case diary, that has been rejected.
This is all right,
See
my
now?
lord. What I am saying is that your lordship will see from lower court, seen, and then pass. I am on that. Even if your lordship does not grant me bail, it's a serious. The IO behaves like this, and court is informed. Court will not take any action. In ordinary course, I would have requested your lordship to issue a show cause notice. Why public prosecutor is supporting IO, I do not know.
And
This is
Lordship,
very
if I
serious
may
matter.
add, my lord, this is the way this function. In such matter, the police are functioning. But my learned senior friend is pointing out today, my lord, this is not only one case, my lord. Many cases, lordship. They will not send the case diary after the charge sheet. They will file the charge sheet thereafter, my lord, taking time. my lord.
Lawyers are the only agency to
And-
inform the court.
And we
Your,
are-
your
my
lordship
lord,
has seen this.
We have also come across with 2-3 instances in the
Lord.
case wherein they have
the whole
recorded
case,
this
lordship, is based on documentary evidence. One failed it, forging, failed it, my lord. That also 2007 to 2013, my lord. The last
Hear
case
it at
is
2.
lordship.
Go
Obliged.
by the case there.
May I please, your lordship? My lord, this is a petition, my lord, it's a quashing of a complaint case, my lord, which is pending before the SDJM Lakhipur. Here in this case, my lord, before taking to the concerned impugn affair, my lord, I'd like to say a little background of the case, my lord. Here, petition number 1 is the husband of the respondent number 2, my lord, and rest are my mother, my married sister, and my 3 brothers, my lord. That I got married with my marriage solemnized with the respondent number 2 on 9 March 2023, my lord. Kindly, that may be important. 9 March 2023. After 10 days of my marriage, my lord, I received some photographs and certain that the present respondent number had the intimate relation with some other person, my lord. Then we queried about the fact, we informed about this fact before their family members. Then they threatened us not to disclose this fact. And accordingly, my lord, during pending, after 17 days of my marriage, that respondent number 2 lost the complaint case before the judicial magistrate on 27 March 23. That means after 17 days. Lordship, kindly have a look on page 29. That after that vernacular, my lord. Also, I typed it. Vernacular is very relevant, my lord. So I am allowed to read this vernacular. Page 29, my lord. Here, lordship will find first, my lord, the date of filing of this complaint on 27 March 23. Then, and marriage was solemn with me on 9 March 23. That means after 17 days. Badir Nam, Farhana Begum Chaudhuri, and Badir Khatti Soencho, my lord, and Bibad against whom this complaint lost, my lord, it is the Subrojit Malakar. Then, my lord, the case is registered Ainor Dara 420, 420, 376, 320, etc. নিবেদন এই যে বিবাদী একজন প্রতারক প্রকৃতির লোক বটে বিবাদী এলাকার নিরীহ মহিলাদের সঙ্গে প্রতারণা করিয়া থাকেন আমি 2021 সনে ওমেন্স কলেজের ছাত্রী ছিলাম এই সময় কলেজে পড়াকাল বিবাদীর সঙ্গে আমার ভালোবাসা স্থাপন হয়েছিল বিবাদী ওই সুযোগে আমাকে বিবাহ করিবে বলে মিথ্যা প্রতিশ্রুতি দিয়ে আমাকে বিভিন্ন স্থানে বিবাদীর সুযোগে বিভিন্ন অশ্লীল ফটো তুলিয়া আমার মোবাইল ফোনে রাখিয়া আমার সঙ্গে শারীরিক সম্পর্ক স্থাপন দর্শন করিয়াছিল বিবাদীর সঙ্গে আমার শারীরিক সম্পর্ক স্থাপন দর্শনের ফলে আমি অন্তঃসত্ত্বা হইলে বিবাদী আমাকে হাসপাতালে নিয়ে আমার গর্ভপাত করাইছিল এবং বিবাদী আমাকে বিবাহ না করিয়া তাহার দেওয়া প্রতিশ্রুতি লঙ্ঘন করে আমি সমাজে অসম্মানিত হওয়ার তত্ত্বে বিবাদীর বিরুদ্ধে কোনো মামলা মোকদ্দমা করি নাই তৎপর বিগত 9/3/23 ইংরাজি শিশুপাটের ৭০ নিবাসী মৃত নাসির উদ্দিন চৌধুরীর পুত্র নুরুল ইসলাম চৌধুরী দ্যাট ইজ পিটিশন নাম্বার 1 মিলজ নুরুল ইসলাম চৌধুরীর সহিত আমার সামাজিক বিবাহ হয় আমার বিবাহের পর বিবাদী আমার স্বামীর মোবাইল ফোনে উক্ত অশ্লীল ফটো আমার গর্ভ সংক্রান্ত বার্তা প্রেরণ করিয়া আমার সঙ্গে প্রতারণা করিয়া আমার স্বামী গৃহ হইতে আমার সংসার ভাঙ্গিয়া তাহা তাড়ানোর প্রচেষ্টা করিতেছেন তো ও তাহার সহিত শারীরিক সম্পর্ক স্থাপনের কুপ্রস্তাব দেয়। বিবাদী বিভিন্ন লোকজনের মোবাইল ফোনে হোয়াটসঅ্যাপে উক্ত বার্তা পথে আমার সঙ্গে প্রতারণা করা দায়ে আমি নিরুপায় হয়ে বিবাদীর বিরুদ্ধে অত্র নালিশ দায়ের করিতে বাধ্য হইলাম। এমত অবস্থায় আমার অত্র নালিশানা গ্রহণে উপযুক্ত তদন্ত সাক্ষ্য প্রমাণ নিয়ে বিবাদীকে তলব করত সুবিচারিক ব্যবস্থা গ্রহণ করে একান্ত আবশ্যক নতুবা ক্ষতির স্থল বটে। অর্থে প্রার্থনা উপরোক্ত কারণে আমার নত্র নালিশখানা গ্রহণে উপযুক্ত স্বয়ং সাক্ষী প্রমাণ দিয়ে স্বয়ং that is on 27/3/23. Then my lord, annex of phone very next page 31. When this facts her past life exposed before us, my lord, then my lord, to save her, my lord, this is the case under section 94 CRPC file. She brought at the time of marriage in her house, my lord, to recovery all this material. She filed the instant case, and the honorable court learned SDGM on 6/4/20 this order passed, my lord. This is very important order, my lord. The peruse the complaints petition supported by an affidavit. It appears that the complainant was married with the second party on 10/2/20. It is 9/3, my lord. According to the Islamic Sharia Act, it was also stated by the complainant that at the time of the marriage, articles and objects were given by her parents as per rights and customs. Now it is alleged that the complainant is being tortured both physically and mentally by the second party member. That the first party left her matrimonial home due to the serious physical and mental torture second party, and then she living at her parent home. Now the complaint is apprehending that second party may sell those articles for the wrongful gain, and also peruse the complaint petition along with the first list of articles. I am satisfied to the draw of a proceeding under section 94 CRPC directing the officer in charge of the Lokipur police starting to make a search of the house of the second party, the members and others probable places, and recover the article as per the list enclosed census. Accordingly, my lord, that is, my lord, she lost the complaint against that person, my lord, on 27/3. Then on 6/4/23, she filed this case against me, my lord, that for recovery of the articles she has brought at the time of marriage. Now, my lord, the affair, my lord. After, my lord, the just complaint I read before lordship on 27/3/23, my lord. On 27/4, after 1 month, my lord, she withdrawn that application, that complaint, my lord, by the respondent number 2. Just to, my lord, to lodge this present affair to harass us, my lord. That affair loss will find at page 19, Annexure 1. The date of lodging of the affair, my lord, that is 11 May 2023. That means, my lord, we got married on 9 March 2023, my lord. Then she filed a complaint case against that person on 27 March 23. Then, my lord, on 6/4/23, she filed a complaint case, under section 94 to recovery of the article. Thereafter, my lord, on 27 March, April, she withdrawn that complaint, and after withdrawing that complaint, she knew that if that complaint is pending, she cannot harass that. Accordingly, thereafter, she lost this affair against me and as my family members, my lord. Here, lordship, the informant got married with the accused number 1, Nurul Islam Chaudhary, Constable BSF, as per the Muslim rights and ritual by fixing deferred mahar and amounting rupees so, and it was arranged in social marriage. That at the time of marriage, informant parents gifted marriage articles as per the capacity. Then informant accused number 1 started conjugal life at the matrimonial house. Initially, everything went too smoothly and happily, but after few days, most illegally accused number 1 in collision with the other accused 2 to 6 with their ill advice started asking and demanding informant.
What is the stage of the case at
My lord, at first information received, the search sheet, my lord, procedure evidence is yet to be started, my lord. And my lord, here one additional.
498A case, there are sufficient allegations against you all.
No, my lord, absolutely no, my lord. First of all, I have filed one additional, my lord. I am praying for here, my lord. One additional affidavit I have filed, my lord. That she has withdrawn, my lord. That complaint case lost against that person, my lord. One Subrajit Malakar, my lord. The allegation of 420, 370 are also there, my lord. That is, my lord. In my additional lordship will find.
So how will it affect the
yes, my lord, 49.
withdrawal of this one?
My lord, after withdrawal of this case, the present affair has been lost, my lord. First of all, lordship has also gone through. I have read that in the vernacular, my lord, that even she got pregnant, my lord, and abortion, my lord, all these things he suppressed, my lord. When he protested this, why you have suppressed all these things? Then, my lord, to save herself, my lord, she filed under section 94 petition to recover all these things. Then she withdrew that application, and year after all these things done, my lord, the instant affair lost just to harass us, my lord. And now we need protection, my lord. And under similar circumstances, my lord, the Honorable Apex so recently, my lord, and had taken one landmark judgment on this point, my lord. So how this under section 490 misusing this section, my lord, and elaborately discuss all this case. If your lordship permits, I just, my lord, some paragraph I have marked it. Kindly, my lord. It's the latest judgment, my lord. Paragraphs already I have marked it. So instead of lordship time, my lord, lordship may have gone through this, my lord, paragraphs and ultimately quashed it and discussed all these things, my lord. How this section is misusing by the all this relevance paragraph. Lordship may kindly be perused and we may be protected. My mother is 6 years old, my married sister earlier, my 3 brothers are there, my lord. And in the complaint petition, she has said that we had a very good relation. After 5 days, my lord, she said that we made this demanded this dowry. So such kind of process, my lord, it's a very abusive process of law. We may be protected, my lord.
Part Mr. PK Dekhan, part Mr. This is an application which is issue notice to the respondent number 2. Also vote for the scan copy of the respondent number 2. Subject Mr. Dekhan that the copy for liquidation, the false and concocted allegations are brought against the present accused, all the present accused, only to harassment and only to save her skin from the earlier incident and only to save her skin. He submitted that the petitioner earlier launched an FIR against one against one Suprajit Malakar, SUPRGIC Suprajit Malakar, before GMC, Suprajit Malakar, alleging Malakar was news and social which was registered under section 120p 20 328 313 article, but subsequently she withdrawn the said case and up thereafter only some false concocted and only to save her skin she lodged the present FIR with some false and concocted allegation against all the petitioners. Accordingly, so submitted that the further proceeding in connection with
Sorry.
B stage, in the state of list, maybe state in disposal of state, considering it support this support stakeholder of the next stage. Till next date of listing, it is state, it will be listed after 3 days. Next day for the respond number.
My lord. Deep lord.
After admissions. For afterwards. No?
Kindly pass over time for time being.
Hmm? Yes.
Time being, madam.
Time.
May I please, your lordship. 439 application, lordship. Arrested on 9th May 2024. Allegations
When
are
you have lost this FIR case?
FIR is on lordship.
No. Your petition, you have instituted this petition when?
Lordship.
This petition was instituted when? This petition?
This petition was
Prior to 17 or after 17?
prior to 17. Prior to
Prior to
17.
Okay. Yes, what I have submitted, this is 439 then.
FIR is on page 12, lordship. Type copy is on page
You
7,
have
lordship.
case diary here.
Yes, my case diary received, but my injury report is not available in the burn injury, my lord. Injury report is not available in the case diary. But some photographs of the, my lord, that burn injury is available in the case diary. And my
Anyway, your petitioner is in custody since when?
83 days, lordship. 9/5.
83 days.
83 days.
Reason behind
Your lordship may kindly peruse the statement of the 161 statement of the victim, my lord, that was taken by the IO at the GMCS itself with the assistance of the doctor, my lord. And
She is still alive or she is died?
is still alive, my lord. And my hard photograph of the burn injury is also available in the case diary, my lord. One photograph also available. Before the 161 I have like,
But obviously, all these are things are there. He is 83 days.
Yes, sir. Considering the
It can
till
be
now, my lord,
listed-
injury report is also not available in the case. Otherwise, it seems that seriously injured.
Very seriously.
Very burn injury.
Though active injury report is not available, but still,
Yes.
yes,
Yes.
up to you, or we can fix it after 3, 4, 5 days.
Yes, sir.
If by that
Yes.
ready.
Already, Lordship may say that it is 7 location. After sixth or 7th location, most probably, the CD has arrived. So IO has got sufficient time to collect. Considering the progress of investigation and the length of detention.
Very serious nature.
On Tuesday, then 6. Today is 83 days. On 8th of August, 8 Thursday.
CD will be retained at
Yes.
that time.
In the mean, I will check the IO regarding the injury report.
Then if we call by the injury report, then we definitely will come to know whether case is ready or not. Otherwise, case is very serious.
CD may be retained.
It has percentage of burn, most probably
Yes.
maybe 60 to 70. It would have been most probably 70 to 80, 90. Then we should have died. The photograph we have seen,
Yes.
it's a very serious case. He may be under intoxication, whatever, but such kind of very serious in it. So just one thing. We'll retain this CD because it will not be sent back. Otherwise, it will again may take time. So the had Mr. D. Medi, the learned counsel for petition. Item number 20. And also had CD received, but it is submitted by Mr. Potter that CD is not accompanied with the injury report, which is necessary. In the meantime, in the same time, Mr. Medi submitted that he is in custody since last 83 days, and hence considering the nature of and considering the length of detention, he may be indulged on bail. Next, considering the submission from both sides, I find that injury report will be necessary, and accordingly, Mr. Pottakur is hereby asked to take initiative to obtain the injury report from the IO concerned. List the matter accordingly on. You are saying 8 or 6?
Lordship, can it be on 5th? And only Lordship, because after 6 I will be on medical, for medical reason I might not be able to come. Can it be on 5th?
Okay, 5th.
Next Monday, Lordship.
Next month. 5th corridor. CDB detained till next date of this.
Obliged.
May I please, Your Lordship? (439) application, Your Lordship. The petitioner are behind the bar since Lordship 18/5/2024, Lordship. As on date, 73 days, Lordship. Already 72 days behind the bar. And Lordship, the allegations are under section 489A, 489C is there, Lordship. Fake currency, Lordship. It is alleged that, Lordship, about 92,000 rupees of fake 500 rupees FICN note is recovered from the joint possession of the petitioner. Lordship, as they are already 73 days, Lordship, and custodial interrogation at this stage, Lordship, cannot be required.
Only note was recovered or any other machineries and all?
No.
Note and mobile phone, Lordship. The notes and their mobile phone.
$184 notes of 500.
500
Yes, Lordship. 184 notes of 500 notes, Lordship.
Amounting to 92,000.
92,000. And 2 mobile phone also seized, Lordship. That much, Lordship.
Was your petitioners were also on police remand earlier?
Yes, Lordship.
Yes, police remand prayer was there.
Yes, Lordship.
Yes, Sharma.
Lordship, they have admitted the same lordship. They used to supply fake currency notes. For 50,000, they used to supply 1,50,000 of fake Indian currency notes. That is the allegation. They have implicated one more person who is yet to be arrested from Guwahati area. They are residents of Meghalaya. Lordship. At the moment, that is the allegation.
Lordship, we have
They are the residents of Meghalaya. Lordship.
These persons also.
Yes, Lordship. 3 persons.
Oh, yes, from Meghalaya.
Yes, they have implicated one person from Guwahati that he is also involved, but that person is yet to be arrested. That is the progress of the investigation. And Lordship, one more thing, yes, the notes have been sent for FSL. That report has not been received.
May I please, Lordship? First they were forwarded, Lordship, on 19/5, Lordship, and thereafter, after police custody, they were forwarded on 21/5, Lordship. And they have cooperated with the investigation, Lordship. Whatever the statement of the petitioners was already recorded, Lordship. And for further investigation, if required, they will cooperate with the investigation, Lordship. The stringent condition may be given, Lordship. Already 73 days, Lordship.
Part inspected London Hospital. Also, part of additional BP every month we have to respond. This is an application connection receipt submitted by Mr. Thakur that their consent committed such offense as a result of the FIR. However, they are in custody since the 72 days, and thus the IOG was sufficient time for their custody determination. They were also in demand for consideration, and thus they cooperated with IOG in the investigation of this post. However, they are still ready and willing to cooperate with the IOG in further investigation. They are granted with the privilege of bail. Mr. Sharma submitted that there are sufficient implementing measures against the present petitioners, and that they also admitted admitted that they dealt with the fake currency notes. Full stop. However, they as per the statement of the accused petitioner, one more person from Guwahati is also involved in the alleged offence, and police is yet to book the said person. Mr. Sharma further submitted that the FSL report is yet to be collected, and the investigation still under process. Updated submission that on the focus and on result that it is seen that though there is progress in the investigation, but the FSL report is yet to be collected by the IO. At the same time, one person is yet to be booked in connection with this case, who also may be involved in the effort. So, considering these aspects of the case, I find that the probability of finding the charges with the statutory fit is very less, and at the same time, it is that I got sufficient time, opportunity to interrogate the petitioners, keeping them interested, and the further interrogation may not be necessary for the interest of the investigation. Where it is pending?
Hello?
Case of is a case of?
439, Lordship.
No.
Oh, yes, Kamrup Metro, Lordship.
Kamrup Metro. I would rather give 1 2 security of 30,000 security of like amount. One should be compulsory.
Okay. Surety, my lord.
Surety 30,000 with 2 surety. One should be a common subject.
My lord. Deeply obliged, my lord.
24 Lordship, charge sheet has been submitted.
Why 23? What happened? Oh. 24. None appeal.
Lordship, charge sheet has been submitted.
Okay.
And petitioner was on interim law.
None appeal call for issuance. So, a corrigible. Therefore, interim may be extended for 10 days. CS number, yes.
CS number 25/2024, dated
25,
31/1/24.
Dated
31/1/24. 31st of January.
So you will be disposing matter.
Here also Lordship, charge sheet submitted.
After same FIR or
No, different FIR, Lordship. This is from Khetri, Lordship. The previous one was Sonapur.
These are all cattle.
Yes, Lordship, Kettle.
25 also CS submitted.
Yes, Lordship.
CS number.
CS number 31/24, dated 29/3/24.
There also he was in custody.
Yes, Lordship, they were interim.
Dated 29/3.
29/3, Lordship, yes.
But case was filed
On 2023, Lordship. 29/3/24, Lordship. March.
No, but
They filed this on 7/12/23.
neither. Oh, interim was granted in the year 2023.
Yes, Lordship, 2023.
Oh, 2029. They remain absent also in duty, other three duty
Yes.
occasion also. This is good, this is good.
29, Lordship, petitioner is on interim and CD has not been received.
Petitioner is in interim.
Yes.
CD not received.
CD not received, Lordship.
None appears on call liquidable. CD not received. Issue reminder. Estimator. When it can be listed.
19/8.
Interpreter. At 5.
Yes,
Yes, you are.
One 30 report was called for.
Report was?
Earlier, report was called for regarding whether the Hafizul Haq Bepari and Hafizur Rahman are the same person or not. But my instruction is that land has opinion, I don't know. But my instruction is that they are two different persons. There is no case in my name. And Hafizur Rahman, he is an accused and he has been granted bail by the court below, my lord.
What is your name?
My name is Hafizul Haq Bepari.
Hafizur Haq Bepari.
Another
You are not Hafizur Rahman.
There is another person is Hafizur Rahman, and he is not with me, my lord.
Against whom the case is there?
Yes.
But we have sent signal, but written report not yet received. But still, there is, I have found only one note of the IO. Hafizur Rahman, alias Hafizur Haq Bepari. This is not Hafizur. This is Hafizul. Here Hafizur Haq Bepari, but town and first name or village, that is also not mentioned by the IO.
That is that person is I am from Matia and that person is from I am from Dudnoy and that person is from Matia.
No, earlier only name was there Hafizur Rahman. Subsequent notice that Hafizur Haq Bepari, but this is Hafizul Haq Bepari.
No, this cannot be. You have to call for it.
Without
Report has to be there.
Without report, we have sent signal. Now, they have not bring like the CD. Now, today morning, I have talked with the OC. He said that I need to verify from the CD, then only I can tell. They have not taken back the.
But there was an order from on 18/7.
Yes, madam.
SP order was there on 18/7.
Yes,
Verify
madam.
and report accordingly.
Yes, madam. We have sent signal also, but they have not taken back the CD. Interim.
No, it is subsidiary case, my lord, and police is searching me. There no interim is there, my lord. And on subsidiary submitted, other person they are appearing in the court, my lord. There is no any other problem.
No, you are. This is a charge sheeted case.
Subsidiary. I have mentioned I have filed a subsidiary also here. Subsidiary I have submitted also.
65.
In which case you are searching for?
I have submitted subsidiary.
Dudnoy.
Yes, my lord, Dudnoy.
Dudnoy 6521.
My name. And my name is also not in the search sheet. And also in Azhar also, my name is not here.
We need to report that. How can we?
Well, unnecessarily they are harassing me and pulling. Search sheet is submitted. There is no my name.
Dudnoy 65.
You see this the address sheet first. Address in charge sheet. In charge sheet, this Hafizur Rahman is shown as an absconder.
No. He is no, he was a grand.
No, I have
Search
checked
submitted.
earlier. I don't found any name of Hafizul Haq Bepari. I have not found. Because of that order was given on 6/5/24.
No, in charge sheet, what is the name?
That is Hafizur Rahman.
Hafizur Rahman.
Only Hafizur Rahman.
My lord.
And said Hafizur Rahman was arrested earlier?
He I arrested, I don't know. I am not his advocate, but now he is in appearing in the court.
Whether said Hafizur Rahman was shown as an absconder?
My lord.
No, I am told, my lord, that he is not arrested. Now he is appearing in the court, my lord. Search is submitted. He is appearing.
But one notice required, my lord. The arrest, my lord, past trust is
Then
given.
why don't you appear the trial court?
Police is harassing me.
No, trial court below you can appear one.
Trial,
Police is harassing.
I also filed a petition for the trial court, my lord, session judge, but that is also rejected my petition. And kindly one sentence, my lord, kindly see page 46, my lord, my petition. Kindly one sentence, my lord, page 46. There is an order passed by the court below, my lord. Here the accused so and so, and another name is Hafizur Rahman and Safiqul Islam are present. That means they are appearing in the court. Page 46, your lordship, NSFC. And that Hafizur Rahman, my lord, is turning, pulling below that. Resolution got it. Clearly mentioned that Hafizur Rahman and Safiqul Islam are present. That means they are in the court. Charges submitted, they are appearing, their trial is slowly going on. And police is, I have mentioned my petition, police is visiting my house time and again. So, some problem is there.
On what basis police is visiting your house? There is no warrant also pending.
No, nothing. No warrant, no other any other case, nothing.
I can understand on which basis police is searching you.
That is, I don't know. Police is searching.
Police is searching whether
my name should be in the search
case or other case. Specific order was there on 6/5. I have written letter also. But
so my submission lordship, let the police may not be harassed me without any case, whether in my search or in Miller. That modern may cost.
So there, how many accused persons were there as a whole?
There are Miller altogether total accused Miller 50, 65, about 81.
Several persons because of the and earlier this is
this is regarding theft of motorcycle, etc. Miller, and there is a racket Miller.
Hundreds of motorcycles were this is racket.
But nothing recovered from my house and from my possession. That is not my. That is I am here.
One last chance may be given. I have already talked with the OC, not the IO, today morning. Because earlier I have gone through the case. Today morning, he said that I have to take from the remain part of the CD. So, matlab, after the search sheet, further investigation also going on. Because of that, now this part CD is available with us.
My submission, Lordship, let my friend take me some time more. But till then, my lord, police may not harass me in without any spirit case or warrant. There is one, my lord. So that I can live peacefully. I have a family, my lord. My father, mother is there.
More sticky liquid.
I can lie away and till then, my lord, I may not be harassed by and they have taken sufficient time, my lord, in the name of Lord that I will be getting.
Hard. Also hard, Mr. TK Prat. Mr. Maharashtra that the sleeping slip has already been received, but there is no separate report from the IO concerned regarding the identity of the present petitioner as to whether the present petitioner is also required or required in connection with the case. In connection with Goodnoy PS case number 65. Mr. Rashid submitted in this record that he is a different person and the person named Asif Hafiz Rahman has already appeared before the non-appeared court below, but without any basis. The police is searching for him and hence he may be given some interim protection till the visit of custody. Procedure going here. Considering the submission with the council later detailed leadership would be called for from the IO concern and as to whether the present petitioner is the required person is required for in connection with Goodnoy PS case number 65 and will take note of the the police IO is thereby directed not to take any coercive action against the present. It is the matter according to when it can be listed.
19th of February, August,
9th of August.
19?
19.
Or interim 9? Interim
9.
12,
Huh?
12.
12. So he will be giving interim in a sense, no coercive action shall be taken. We have given because particular case, I don't know whether he is required or not. So 12/8. 12/8.
12 but my own family. Till then, I may not be harassed by police.
He has no coercive action. I have already.
Then my lord, after 15th of August, my lord, on 20. 20.
20. 208. Okay.
20.
I'll report it will ready. Okay. Report it.
I am in interim bail, my lord. CD was called for. Allegation is that against the accused number 1, their petitioner before this honorable court, he is at serial number, my lord.
He is in interim, my lord. Some time will be required. PM report not yet received.
PM report.
PM report. My lord.
Is it 302?
302, my lord. One person went out from their house, my lord. Thereafter he did not return the house. That is the, but one person accused number 1 called his name, my lord. But I am
On the next one, my lord, dead body.
Return the case diary or what?
Case diary received, my lord. Case diary.
No, you want to return it back?
Yes, my lord, because some more investigation also will be required. My lord, till now, he is only a suspect. My lord, there are some other persons also in the my lord FIR. My lord, on the next book, my lord, the next day of the incident, my lord, dead body was recovered in a paddy field. But my lord, till now but I have gone for the other parts of the case diary. Till now, there is no such. My lord, already he is interim, so I will get the updated case diary.
Heard Mr. H. Das, the counsel for this and also heard Mr. What?
And my lord, his statement is also not available in the case diary. If till now he has not appeared.
November. I have no idea.
So till now, if he has not appeared, my lord, after obtaining interim,
Possibly he appeared. Man.
case diary, my lord,
It's
his
not available.
no, my lord, his he is up to 15/7/24,
Yes.
not of the IO, but my lord, he
15/7.
15/7, my lord, recent.
Because but your interim was on April 26/4/2000.
Then he appeared possibly, but I have not taken
Don't
it.
have any instructions. So,
There is
Mr.
no
What
such note of
submitted
the IO
that,
regarding his appearance.
though the petitioner was on interim, but his statement is not reflected in the case diary. At the same time, he submitted that the PM report is also not available in the case diary, may be required, as the and the investigation is still under progress. Calls next one, consider case later updated case diary be called for along with PM report and the next date of listing the petitioner will be the interim player interim order will be extended till next date of listing. However, the the petitioner is never directed to appear before the before the IO, IO 57 from the date of order and record equipment if not earlier recorded. It's accordingly when it can be listed.
Yes, sir. On my lord, 9th of September, my lord.
Now see, we are giving another chance to appear before the IO because your statement is not
Yes,
clear.
madam.
And you have not.
If not appeared, when
Yes. 19.
last minute.
Your Lordship, the medical report was called for, Lordship.
You are for the informant. What was called for medical report?
Medical report, Lordship. Really,
It's a case of 326-307.
Lordship.
We can fix it another day then. Petitioner even absent. None appear on call, but CDC as reported by the CDC listing. When it can be listed?
Next week, Lordship.
Next week. Next week can be 7. Till then, CDB retain. Your good name is here?
M. Nirola. For the info.
M. Nirola. For the info. Okay. Here we call for the FSL, I think, na?
Yes, Lordship.
Along with the report,
Not received,
there,
Lordship.
then again FSL.
Lordship, we'll need some more time, Lordship, because the PM is there, but the final report is not here. FSL report is not here. And Lordship, there are some materials against the present petitioners, Lordship.
None appears on call for the petitioner side. Post of, however, it is submitted by Mr. Sharma. The learned petition PP that no case diary is received. The FSL report and the FSL report is not FSL report. So PM report, is there any opinion?
No, Lordship. That opinion is pending.
FSL report and the PM report opinion is not yet received. And submitted that some more time may be required for the same. That's what CDB done accordingly, calling updated case diary along with the PM report and the list accordingly for long distance
28-8.
2018.
May I please, Your Lordship?
Yes.
My Lord, the FIR is page 11, my Lord. There were the 4 persons named in the FIR. Out of these 4, my Lord, page 11, my Lord, 2 and 4 was arrested, my Lord. 2 and 4 in the FIR, already they were arrested and they are released on bail also. And my Lord, the present petition number 1 and 3 before Your Lordship. From the FIR 1 and 3. But the fact is that the present accused number 2 in the FIR, his wife and that alleged victim. Alleged victim is the brother of the informant. They have developed the FIR, man. Both are married, they have children also. And after some days, my lord, the wife of the present accused number 2 realized that it is wrong and by mistake they have, and she picked up the relation. And my lord, on the day of LS incident at night, my lord, the informant's brother, who is the LS victim here, he went to the house in absence of the husband, that is accused number 2 in the affair, Rafiqul Islam. And in the meantime, my lord, that LS victim tried to commit some bad relation. Suddenly the
With the wife of
wife of the accused number 2 in the affair. And my lord, the informant's brother, he is LS victim here. And suddenly the husband, that is accused number 2, entered in the house, my lord, and found the person is trying force with his wife. Then admitted fact he assaulted him. And there was a halla. And present petition number 1 and 2, they are the own brother. After getting that halla, my lord, they have reached there. In the meantime, the incident is over. And people come, other villagers also come and confined him in the house and call the police and handed over to the police. And they have filed this FIR, my lord. The story is prepared, not mentioned on what ground, my lord, the dispute was arise here. Only mentioned that they called my brother, and when my brother went to the house, and they, my lord, assault him very badly, and his telephone, mobile phone was switched off. And when long time it was found switched off, then family member, my lord, thought something happened. They come and found him, and that is the case, my lord. And page 17, my lord, from the present petitioner's side, my lord, that is the wife of that accused number 2 in the affair. She also lost the affair. She disclosed in the affair, my lord, all the story that earlier it was a relation, she admit, but now she break up the relation. And now the LS victim, my lord, trying to do such type of activity. So my humble submission, my lord, though the LS victim, that is the brother of the present informant, assaulted and admitted fact, the present petitioner, they are the own brother. They did not torture him. Even when they come, they stop to torture because the husband of the lady, my lord, he was excited. He was very emotional and very excited. He assaulted him. But now whole the family member, 3 brother and 1 brother-in-law, they have involved in this affair. So my humble submission, the husband who assaulted and other brother-in-law, they were arrested next day, and honorable court already released on bail, my lord. The present petitioner, since they are the brother only, well, their name has been involved in this case. So maybe consider on that aspect, my lord. Both the affair, my lord, I have annexed. alleged victim was assaulted, it is admitted fact, but not by the present petitioner. They prevent. Otherwise, it would have been more serious.
And Lordship, here the medical report of the victim, his legs and hands were fractured, Lordship. And Lordship, there are independent witnesses who have stated that yes, the Rafiqul, the husband of the woman, Lordship, he assaulted, but they all participated, Lordship. They have categorically stated Rafiqul Islamor ঘৰত হাল্লা শব্দ শুনা পাই আফজার আলী আব্দুল হাকিম is the petitioner number 1 আৰু টিকেন আলীয়ে that is petitioner number 2 আগবাঢ়ি আহি ঘটনাৰ বিষয়ে শুনি তেওঁলোকেও জখমী সিয়ামত আলীক কিল ভুকি ঘুচা মাৰি জখম কৰে that is the statement of every independent witness that is the case.
In fact, no admitted fact, Rafiqul has done murder. They have subsequently come. So that husband was excited, and wife stated all the story. These are happening with me. So the present
Apart
petitioners
from
will be
fracture
considered.
injury, did he receive any other injury?
No, Lordship. That report is still awaited, Lordship. Final report is not received. In fact, the statement of the injured person is also there, Lordship. He has also stated the same thing. Lordship will find in the top bottom portion, Lordship, the description of the injury. His legs, hands were broken. And if Lordship kindly goes to the third flag, Lordship, independent witnesses, I have flag mark, Lordship.
The husband already released man. Husband and another person, my lord. So very unfortunate case, my lord.
Third flag, Lordship.
Because what is the involvement of the present petitioner, my lord? Can you examine?
There are number
Because
of
they are the relative. Whether anything happened, my lord, at house, definitely relative will come. It does not mean that everybody will assault me. Because after over the incident, they have reached there. And it's the system in the affair. In every case we see, if one person will commit any offense and hold the family members involved in the affair, only that is on that ground, my lord, their name has been involved. Even as per my instruction, the present petitioner prevent not to assault him because they have called the police, my lord, and handed over him. At present, he is, my lord, well, my lord.
Mr. And would be done for the counterpart. That the present petitioner are the accused number 1 and 3, 1 and 4. No.
2 and 3 was arrested in the affair.
1 and 4 of the case, and they are not at all involved with the alleged. However, it is a fact that the brother of the informant that the victim was assaulted by the accused number 2, as he found his wife in a compromised situation with the victim. Listening Allah from the house of the accused number 2. These two petitioners also went there and they tried to stop the accused number 2 from assaulting the victim. But they are not involved with the alleged offense. But it admitted that they were also they arrived at the place of occurrence, hearing Halla in the house of the accused number 2. Mr. Sham accordingly they submitted that they are law abiding person and will hope I in further case they are granted period. Mr. Sham that from the injury report and it seems that the victim sustained fracture injury of his hand and leg, and uh, he was assaulted uh, mainly by the accused the accused number two. But there the present petitioners also took part in the state hearing. The submission made by the counsel said, I have completed case diary and considering the materials available in the case diary, other aspects of the case, I find that custodial interrogation of the present petitioner may not be necessary for the interest of the investigation, and accordingly, I find it is privilege of the case to the present. If the affidavit must be to interim, give some conditions there. Okay, both the petitioners will be under interim. No, not under interim. Okay, peers bail prayer is allowed.
May I please? Yes, ma'am.
Your peers bail prayer is allowed.
Yes, ma'am.
May I
Because
please, Your
they will appear before the arresting authority, ma'am.
Yes, obviously. Within
Yes.
10 days, they will appear.
I am obliged, ma'am.
May I please? Item 17, Your Lordship. It is a criminal petition. CD was called for, but initial date the CD was called for, but it is not received.
We need the CD.
Required because that has been called for by the court.
Was not called for.
Yes.
Call for Lordship, not received.
CD not received. Hard Mr. Anand.
I am carrying on behalf of respondent number 2.
Hard Mr. Anand. Counsel for the now for Hard Mr. P.K. Pukas, behalf of respondent number 2 and Mr. Sharma. It is submitted by Mr. Patel not as reported for proper execution. Should remind me what call for CD. Yes, from our
22nd of August. 22nd, I will be out of station.
It will be
22nd, I will be out of station.
Will by call by the registry or you by call by you by you. 22nd.
22nd, I will be out of station.
Out of
25th of
25th. After
25th.
After 26, Your Lordship.
22nd, Mr. Purkas
I'll
will be out of station. 25th, you will be out of station. So it will be on 26th.
28, Your Lord.
28. 28. The 26 is closed, Lordship.
Where Mr.
26.
Purkas is going this time?
Oh, not sure.
Nur Iman Ali, my lord. Nur Iman Ali injured, sustained injury, my lord.
Oh, yeah, petitioner number 1.
Petitioner number 1.
Heard the London Council for the petitioner. And also heard Mr. Report narrated submitted incorrect report in spite of sending that it was an accident occurred wherein some of the public affected the rider of the and
Noor Ahmed Ali
but
year to know.
these petitions are way involved in the LS law.
Do you know what?
Most petition number 1 sustained
Injured one, I know.
was admitted in the hospital and hence not no way involved in the LS law. Accordingly, he submitted that the topic is that they for the positions. That's why hearing this submission made by the London Council for both parties. I hereby deputy petitioner number 1, namely Nur Iman Ali, hereby interim clears of the I find it fitness for the clear receipt of the case diary. However, the prayer for interim bail for the petitioner number 2 and 3 rejected at this, and the necessary order will be passed only on the development case. हमने एक नंबर कॉपी खरीदी को. Your petition number 1 is granted with limited address or not?
Obliged.
According for the case diary, yes, Mr. Who are not in case, I mean, who are not in interim?
Yes,
One is
otherwise all are involved because that FIR was lost later on, and initially one FIR against all of them, they brutally assaulted the that rider of the vehicle, and in that regard one FIR regarding 302 is also registered against all
we are
the
submitting from where?
here from the petition, from the
No, I'm just giving one only
Yes.
for the reason that he sustained injury.
he sustained.
Injury.
That is his version. Later on, he lost after that incident. He lost this FIR. Anyway,
Oh, after that incident,
he lost the FIR.
We lost FIR
Anyway,
on 25/6.
let one mail in interim. Other persons I will get the case diary on 14/8.
Obliged, my lord.
Also, my lord, CD and PM report not received.
It's not this.
Not received.
None appears on
No.
for the this report and submitted CD along with PM. No?
Yes,
CD along with PM not received. Issue reminder. They the better yes, that we will get
On 21/8.
21.
Please, Your Lordship. So, this is 30th application, Lordship. An FIR was lodged against one Somlal Vishnu.
Here we have received the case diary.
It is
Oh, records are there.
Record, I have not gone for the LCR, anticipatory bail,
Transited case.
Yes,
charges have been
charge
filed.
AB, some other day,
Contained the charge.
Lordship.
302, 307, 326. So I'll have to go to the LCR, Today not possible. Next date on
Next week, sorry.
next week, on 7/8/8.
8. When you stick it on 8, by the time he will go to it.
Also, kindly protect me for this period, at least for a week also.
It started at 1302. And the request made by the non-judicial is the matter on 8, you're saying?
8. Anticipated bail, my lord, 302, 307, 326,
Yes.
everything is there.
Deeply obliged.
50? Yes, 51.
May I please your lordship? Well, it's a 438 application, my lord. The anticipatory bail, my lord. The page 12 is the FIR, my lord. My lord, the petitioner, petitioner number 1, 2, and 3, my lord. They are the teachers, my lord. 1, 2, and 3. They all are of an AME school, my lord. 1, 2, and 3. And 6 is the chowkidar of a college, my lord. And 4 and 5 is the contractor, my lord. Well, there's a dispute with regard to my lord, the school, my lord, with the informant, my lord, regarding the provincialization of the school, my lord. Then on that day, there is some dispute regarding the, then which, my lord, the petitioner number 6, my lord, basically. There's a scuffle with the petitioner number 6, but nothing that short of the, as per the allegation, there's an assault by the weapon. That's nothing of that sort. We tried to gone for an amicable settlement, my lord. But subsequently, the informant, he bumped his own head on the wall, my lord, and made this kind of an allegation, my lord, that he has suffered. Well, I think in these cases, my lord, the custodial detentions are not necessary for the petitioner, my lord. They will face the consequence, my lord, if tomorrow the charge sheet is filed. There is no, my lord, material of 307, though the 307 has been added, my lord. Absolutely no material from the face of the FIR itself, my lord. And these are all teachers, government servant 1, 2, and 3, my lord. The case there will, my lord, definitely.
Yes.
Well, as per the injury report, well, he sustained grievous injury by sharp weapon. One injury is 3 centimeter into 4 centimeter and 2 centimeter deep.
Where? Where he sustained?
Top of the head.
That is our case, my lord. He has bumped his head into wall, my lord. And there is an allegation of the petitioner number 6, my lord. There is one injury, my lord. All the accused person, how they have been roped, my lord.
And as per his,
Where you are saying that this is the allegation against accused number 6 only?
My lord, as per our instruction, my lord, there is initially, my lord,
No,
there is
I'm just searching in the FIR.
FIR, my lord, only the omnibus statement, my lord. That's an omnibus statement implicating all the accused, my lord. There is only one injury, my lord.
and as per his statement, my lord, his statement, victim statement, informant statement, my lord, on 12/7/24 তাৰিখে দুপৰীয়া 1:30 বজাত মই মছজিদৰ পৰা ঘৰলৈ আহি থকা অৱস্থাত আছামী হুছেইন আলী সিকদাৰ, আলিমুদ্দিন, নুৰ হুছেইন, জুলহা চালাম সিকদাৰ, মঞ্জুৰ আলম সিকদাৰ, ৰাজু সিকদাৰ আৰু কাছেম আলী সিকদাৰে পৰিকল্পিতভাৱে একগোট হৈ মোক হত্যা কৰাৰ উদ্দেশ্যে ঘৰৰ সন্মুখৰ ৰাস্তাত আগত ধৰি কোনো কাৰণ নোহোৱাকৈ ঘোচা কিল মাৰে আৰু মোক চোকা অস্ত্ৰৰে মূৰত আক্ৰমণ কৰি জখম কৰে আৰু লগতে মোক ভৱিষ্যতে হত্যা কৰিব বুলি ভাবুকি দি গুচি যায়। But who assaulted with that is not specific. Otherwise, my lord, he took the name of all the petitioners. And as per section 118 subsection 1 of BNS, my lord, which earlier 324.
That is only, my lord, non-bailable 3 years punishment, my lord. Earlier it was 324. Now it is 118, my lord. 3 years punishment, my lord.
Earlier it was bailable, non-bailable, my lord.
Earlier
And
it was bailable offense, my lord.
109 is 109 of BNS is 307 earlier.
307, there is no material as such, my lord.
The injury is grievous by sharp and head.
There must be intention and the knowledge to kill, my lord.
Other there are no any other
One plus Q. If there is suppose 118 BNS or T24
118 subsection 1.
118 subsection 1 BNS.
Yes.
And that is the corresponding the other corresponding sections of IPC is T24.
Yes, ma'am.
Now it is
See,
bailable.
obviously-
Now it is non-bailable.
No, whatever. This sharp cut injury you are
Yes.
saying. So where is the grievousness? Sharp cut injury is okay. Where there is any grievous injury is that part T24. In that case, T24 118 of 1 BNS is not.
Yes. Voluntary causing hurt or grievous hurt now or given malat.
Oh, it's
118
subsection 1.
two is malat regarding 326.
2 is T26.
But in case listed under section 1. Voluntary
Anyway,
causing
your report says that this is grievous.
grievous. Medical report is grievous by sharp weapon and head. And two witness malat independent witness they have stated that ঘৰৰ সন্মুখত ৰাস্তাত আগচি ধৰি গালাগালি কৰি তৰ্ক বিতৰ্ক কৰে উক্ত স্থানত আগবাঢ়ি যোৱাত সোধপোছ নকৰাকৈ কোনো কাৰণ নকৰে শিল ঘোচা মাৰি জখম কৰে মাৰপিট কৰি they took the name of Allah, Alimuddin Julha, Sikdar, Manzur, all the name has been taken by.
That is fist and blows, man.
There are three independent witnesses.
Is there any specific mention about the
Specific malad who malad blow?
There is no sharp
fist and blows is for everyone, whether it's sharp open, using of sharp open.
Yes, fist and blow. That is not
Is
given.
using of sharp open is
No, none has said malad regarding. Specifically none has said. গোচৰীয়াৰ মূৰৰ পৰা ৰক্তপাত হোৱা দেখা পাইছো পুনৰ চোকালৰ অষ্ট্ৰেলিয়া দেখা পোৱা নাই otherwise took the name of all three witnesses along with the informant inspector.
as per you custody interrogation would be necessary.
My lord, grievous injury in the head.
You will face the consequence, my lord. Why custodial detention, my lord? And the fist and blows, my lord.
For the informant.
Yes, submit your appeal for informant.
I am appearing for the informant. Dear Lordship, if I am not wrong, my learned senior friend has said that petitioner number 6 had some altercation with the informant. But in paragraph 6 of their petition, Lordship will find they admitted that altercation took place with petitioner number 5. That they are also not sure with whom Lordship that the altercation took place. And here Lordship 7 persons surrounded a person who gave that fatal blow he may not have seen. But the participation of all that is consistent. That an injury which is found that sharp weapon and grievous, that is there. And other part Lordship that other threatening part is also there in the FIR itself.
Sharp weapon is not there itself, my lord, as far as the case that is concerned, madam. His allegation is that the sharp weapon we have used all three independent witnesses. Nobody has said that there is only the fist and blows, my lord. They have seen it, their presence, my lord. Where is the sharp weapon, my lord?
If I am not wrong, my learned friend has said it is sharp weapon.
No, injury, as per injury report,
No, person who has independently, who has seen, my lord, they have not said that you have used the sharp weapon. Now, that is the submission, my lord.
Yes,
That was the submission, my lord. Don't mistake. Humayun is like a case that is not as bad.
VA Chaudhary.
And also had Mr. A.K. Prat, everyone here, and Mr. A. Ahmed, regarding council, appearing on behalf of the comment. antecedent case under sections 2 and so in connection with the subject by Mr. Borak that present petitioner has not committed any set of that is in the FIR. The fact that there was a dispute between the petitioners and the informant side regarding the professionalization of the school, where the petitioner number 1, 2, and 3 are working as a teacher. Petitioner number 6 is the shopkeeper, and petitioner number 4 and 5 are the contractor. During that hassle, the petitioner, the informant, had hit with the head against the wall and that inflicted injury on him. But apart from quarrel and tussle, no other incident had happened as that. However, they tried to compromise the matter also. Meantime, the matter also, but the matter has been lost. However, all the petitioners are still ready and willing to cooperate the island in further investigation of this case if they are granted with the privilege of 3 years free. Conflict for Vicky has submitted that from the medical report available in the case diary, it seems that the victim sustained head injury with sharp object as head in a previous injury on his head with a sharp object.
Sir, I've opened मतलब given
Sharp weapon. But from what he submitted, that there is no specific allegation of against any accused petitioner that who assaulted the victim with a sharp weapon. The from the statement of the victim also, it is not clear as to who assaulted him with the sharp. First of all, as per the as per the other witnesses of the case also uttered the name of all the accused petitioners, and as per them, they attacked the victim with fists and rope, but there is no mention about attack of the victim with any sharp. However, he submitted that considering the injury sustained by the victim, custody interrogation may be necessary for the interest of the Mr. Ahmed, the learned counsel for the informant, submitted in this regard that the petition of the document itself is contradictory, and they are not sure as to who, as with whom the altercations started first with the informant. Further, it submitted that from the report itself, it seems that the victim sustained previous injury on his head with a sharp object, and according to the object, submitted that this is not a fit case to extend the privilege of the nearest fit representative. Hearing the submission made by the learned counsel for cases, I have also read this diary, and the fact that there was a dispute between the parties, and as part of the case diary also, it is said that all the accused petitioners are involved in the same gossip and they attack the petitioner code, but there is no specific allegation against any of the petitioners regarding the attack by sharp object. Also, considering the entire methods available in the case diary, I find that a interrogation of the petitioner may not be necessary for the interest of the investigation, and accordingly, I find it of 3 years to all the accused petitioners. Your petition is allowed? there will be some conditions
Yes,
apply also.
Pavlaj.
Highly obliged.
50.
May I please watch? My lord, perhaps additional affidavit is not on record, my lord.
Around 56.
My lord,
56 additional affidavit.
56, my lord.
Additional affidavit was called for here.
My lord,
We have not called for additional affidavit.
in fact, that was not called for inadvertently, my lord. In fact, I was, my lord, under the impression that that will be, my lord, tagged with this record, my lord. In fact, it's not on record, probably, my lord. Your lordship may have it, my lord, along with the, my lord, the additional.
No, we are on item number 56. We are
56.
talking about 56 only.
Yes, yes, my lord.
On Friday, Lordship, last 30, they had raised the point that he is of unsound mind, Lordship, cyber crime.
Oh, acha. You want to file an additional affidavit?
I have already filed, my lord. In fact, that is not tagged, my lord, along with this record, my lord.
Oh.
In fact, that is not needed, Lordship. I have already supplied our additional affidavit, Lordship.
This is
Since
your additional affidavit.
then they have filed the additional affidavit, Lordship. I have supplied the copy which was served to me, Lordship. Lordship can take cognizance of that affidavit also, Lordship.
Oh, that is here in the
Yes,
record.
yes.
Acha. But we have not received it.
So since they have filed, Lordship, it is on record.
So, your lordship may have it along with the affidavit, my lord, any day, my lord, tomorrow or day after tomorrow. Because it should be, my lord, in the record, my lord.
Now what can we do? We can call. Otherwise, you have supplied your copy,
Yes.
but let the copy be tagged with it. And we may fix it on Wednesday then.
Lordship.
Yes, my lord. With a direction to, my lord, with a direction to, my lord, tag the affidavit, my lord.
It is submitted by him that he has already filed an one affidavit in this connection. Now we take with the record. Accordingly, the registry is hereby directed to take additional affidavit filed by stop and let the matter be accordingly reported within it 31. 31.
Lordship, I have a small prayer. Lordship, on Wednesday, it may be taken up at 2, Lordship.
At 2.
At 2, Lordship.
That is on 31/7/2023. The matter may be taken up at 2.
I am obliged.
My lord, there is an interim order, my lord.
Interim be extended till next.
Lord, deeply obliged.
So, Sharma, you have done to the record already.
Yes, good.
I mean, the case diary was a very nice case diary. You have
Yes,
submitted.
yes.
On
Yes.
that day, part submission was there, but
Almost completed, Lordship. Just Lordship wanted to glance at the medical report, Lordship. So, Wednesday will display it.
May I please, your lordship?
Yes.
CD is available 57. Item may be passable for the day. Senior is out of station.
Oh.
in that case, it will be listed on the next week only. So this week we are very busy, and second we do not want to. I do not want to fix much better because we are having a meeting on that.
Next week.
Next week, any Monday, Tuesday, whenever you can.
Well, in fact, here the petitioner also injured, but his injury report is not available. CD is available, 164 is available, but petitioner's injury report also calls for that is not available. Maybe fix on my 7th, my lord.
But they are not in. Oh, 7. In spite of, even if there is no injury report separately, but if there is any
Materials,
statement made by this so that he also sustained injury, that will cover up. So it will be fixed on 7. The request made by the non-responsible is the matter on 7/8/2024. Till then, it will be ready. 7. We are listing it on 7.
Obliged, lordship.
19th.
19th case.
Not clear also. Here, FIR lordship will find at page 14.
What time? Yes, 19. We are on 19.
90. Your lordship, the petitioner is in custody since 14/12/2022. 1 year, 7 months, 15 days, lordship.
14, 12, 2022.
Lordship. 1 year, 7 months, 15 days. And the case is still at appearance stage. Lordship.
What kind of case is it?
NDPS.
Why NDPS is there?
Probably one of the accused persons your lordship has
Oh.
therefore. Nowadays, if one
Otherwise, bench was actually
Yes.
changed. That's why I'm asking.
this bench
So now, whatever the present case, so can I deal with what? Is there any?
Yes, there is a
I mean-
Supreme Court judgment that if one FIR is adjudicated by the one accused bail application is adjudicated by one judge, then other accused has to case also has to be listed before the same
No, that is there, but it's which
roster
Maybe
also.
that's why one was there.
Okay.
Anyway, your commission, as per your commission, 1
Uh,
year,
1
more
year,
than 1 year, 7 months, he is in custody and still at the
appearance stage. And Lordship may kindly see the FIR page 14. From a vehicle, some contraventions were recovered where the present petitioner was there. And if your Lordship kindly see paragraph 6 of my petition, I am a mechanic by profession and I went for the test drive of the vehicle, what problem was there to check that purpose, Lordship. Paragraph 6 I have stated.
Yes.
And that other regarding delay, Lordship, just I am relying on judgment of on compilation. I am handing over to your Lordship. First judgment, your Lordship will find page 1 after those index, Lordship.
Yes, Ravi Prakash.
Ravi Prakash. Your Lordship have evaluation, but I am referring to paragraph 3 and 4 here. 4 mainly only on for 37, Lordship, that the long incarceration was there and therefore it was diluted. Then your Lordship will find page 3. Here also, last paragraph your Lordship will find the appellant was arrested on 21/7/2018 and continues to be in custody. It appears that out of 10 witnesses cited to be examined in support of the case of prosecution, 4 witnesses have already been examined. Without expressing any opinion on the merit and demerits of the rival submission, considering the facts and record, so bail was granted. This he was on arrested on 21/7/2018 as reflected in the order itself, and it order was passed on February 7, 2020. Page 4, your Lordship will get, and therefore his custody period was 1 year, 6 months, 17 days. And then your Lordship will find page 6. Here also the petitioner seeks and enlargement based so and so. FIR under section 21C and 37 of NDPS Act registered at so and so. During the course of hearing, we are informed that petitioner has undergone custody for a period of 1 year, 7 months as on 9/6/2022. The trial is at a preliminary stage as only one witness has been examined. The petitioner does not have any criminal antecedents. Here also, I have no criminal antecedents as per my instruction as from the charge sheet also your Lordship will find. Taking into consideration the period of sentence undergone and all the attending circumstances, but without expressing any views in the merits of the case. So here also, so all the judgment which I have given, Lordship, here also they were apprehended along with some contraventions, but considering the delay period, they were granted bail. Lordship. And my humble submission is that
Why case is at this stage of still at stage of
against one of the accused, Lordship, warrant is issued and he has not appeared till date.
still abscond?
Still abscond. His warrant was issued against 30/3/2024. Last. Against accused Kamaluddin. That is it. So there is no chance of starting trial at an early stage and concluding the same, Lordship. And he has already undergone a substantive period of. So considering that aspect and the fact that he was a mechanic and he was just driving the vehicle for a test, Lordship. Those aspects. Kamaluddin is the main owner of that vehicle, Lordship. Kamaluddin.
Where from the contraband register?
Yes. Kamaluddin owner and Baharuddin from Bahar, one Bahar is there. From Baharuddin, Kamaluddin Lordship purchased. And subsequently it was given to my for repairing, Lordship. I was driving the in between police apprehended.
Yes, Shyam.
Lordship, here at the first instance, Lordship, there were around 4 accused, Lordship, if I'm not wrong. There, Lordship, one was Kobir Ahmed, who was a CCL, Lordship. So that was one reason why the case got delayed, Lordship. Subsequently, his case was picked up on 15/2/23. Case was picked up against Kabir Ahmed. Thereafter, Lordship, cognizance was taken on 15/6/22. And there, Lordship,
How is this taken?
15/6/22, 2022. There, Lordship, Kamaluddin and Baharul Islam were absconding, Lordship. Were shown as absconder, Lordship. Subsequently, Lordship, there were another date, Lordship, on 27/6/23, court was paralyzed due to bund, Lordship. That is from the record I am stating, Lordship. Thereafter, Lordship, this Kamaluddin, he was absent with steps. Subsequently, NBW was issued against him. The other Baharul Islam, Lordship, he subsequently, on the strength of a anticipatory bail, he appeared before the court below, Lordship. Now, Lordship, as per the records, Lordship, the next date, last date was fixed on 12/10/23 for appearance. If I'm not wrong, Lordship, I've gone to the record.
That's 10/24.
23. After that, Lordship, I have not found any up-to-date.
So as per your now how many accused are now absconding?
Now one is absconding, Lordship. Kamaluddin.
Kamaluddin is who was earlier appeared before?
No, he was shown as absconder, Lordship.
16.
Yes. And regarding, Lordship, the contraband, Lordship, there were 50,000 Yaba tablets were seized, along with, yes, along with 213.7 grams of heroin. Altogether, there are 9 PWs, Lordship. So, this is the status, Lordship. And also, I will submit one judgment of our coordinate bench, Lordship. I will just provide the.
And just one thing that I'm pointing out that in my compilation, Lordship, my list is serial number page 20, Lordship. In I'm sorry, page 23. Page 23. Anjan Nath. Here also, one of the accused were granted bail, and here also quantity was used. Even then also our High Court rejected. Then he went to Supreme Court, and Supreme Court said, Lordship, just one line was page 24, taking into consideration the fact that the similarly circumstanced accused has already been released on bail by this court, we are inclined to grant bail to the petitioner. And that order, Lordship, I have enclosed here at page 25, High Court order, your Lordship will find. Here also quantity was used, and here also that ground of delay was taken, but that was not considered. That both order, Lordship, I have given at page 23 onward,
Is,
Your Lordship.
against this order, the Supreme Court order was.
Yes, page 23 is the against that order. Yes. Yeah, in that case, Lordship, around 2 lakh something tablets were recovered. So if my Lordship, the Article 21 is there.
Actually, what is that? There are two aspects of in every this NTPS matters.
Yes.
One is obviously long incarceration was there.
Yes.
So for one, if he suppose he becomes, I mean, he is in the subsequently he is got acquittal, then what we take one number. But secondly, if you, because I have come from the trial court, so I know some defects in the case. If the person is on when bail, it will never, can you will his attendance will cannot be procured by.
But I have
it
come
will be
across-
delayed for 4, 5, 10, 6, whatever.
In this case, even I'm not going to other case. Even in this case, Baharul was granted bail for limited period. He went there, he appeared there, and even till that he appeared. And second Lordship case where I have come across Lordship, and one case Lordship I have come across, your Lordship granted bail in 19 days, being district judge of Kamrup Lordship. Subsequently, he appeared there, regularly faced trial, and he got acquittal also Lordship, in that case. So my experience is that they are appearing Lordship.
And he will pass the order.
Lordship. Any condition Lordship that government employee or he will that condition.
He is from which state or district?
He's from Korimganj, Lordship.
He's from Korimganj.
Just oh, sorry, I'm sorry, Tripura. He's from Tripura. Government employee. Oblige.
My lord, in this case, earlier your lordship wanted they granted some of the accused persons bail who are in my lord judicial custody, my lord. Now this is anticipatory bail because some of the person, as per my instruction, some of the persons say injured, and IO also has collected those injury report. And today, my lord, IO has to send the case diary. Is supposed to send the case diary, but today, my lord, I have not received the case diary.
That intentionally they are not sending the case diary.
My lord, that I cannot say this because my lord, injury report IO has
On
collected
earlier
some of the
occasions
injury
also, my lord, your lordship asked for the injury report only because already case diary has been perused by your lordship and granted bail by to others, my lord. And my lord, he is a school teacher, my lord. And from 1st August, his school will be open, my lord. At least some protection may be given, man.
Yes, this one is that the some of the persons were the
Yes.
death of someone.
Yes.
Yes, my lord.
Custodial death.
Custodial death, my lord. Yes,
attempted
yes.
to my lord attack the police personnel, also my lord trying to burn down the my lord entire police station. Those are
Yes.
the-
And my lord, he is not
Now, where
involved.
here you have otherwise you have received the case diary.
Yes, my lord. Earlier we have received the case diary.
Today is not there.
Today is not.
Today you have not received.
Yes, my lord. The IO has my lord, supposed to send some injury report also in this case.
Well, I will cooperate, my lord. At least till next date, my lord, I may be protected, my lord. I'm a school teacher, my lord. And from 1st August, my lord, the school will be open, my lord. Only for next date, my lord.
Now, what is the instruction says? You have no, this why it was timely matter. You only to take
Yes,
instruction.
I will have to get the instruction.
So now what
From
is
our office, my lord, Mr. Sharma inquired that CD is not available in the office.
I may be protected for till next date, my lord. Only till next date, my lord.
in this some orders. That is that I was not present here or we need the order I think start from the control after order. Orders. Connection.
My lord.
Cooperative.
Yes, my lord. Yes.
We are 46. Yes, what a
On my lord, 10th of September.
How like you? September.
Injury report. Like CD CD along with injury report.
Yes, sir.
How like?
With the 9 keep equalize the pixels. Case has already been raised after all accordingly after this. Yeah, the basic of direct BPS. Got it. So why it is in order column? A criminal appeal is also ready for hearing.
No, appeal has already been admitted, my lord,
Acha.
and the case fixed for my lord consideration of the bail of the appellant, my lord. On the earlier occasion, my lord, this whole court, my lord, asked my learned friend to go through the my lord record, my lord. The conviction has been given, my lord, on the basis of presumption only. The wife committed suicide, my lord, within 7 years. Husband, then my lord, father-in-law and mother-in-law. And in the evidence, my lord, there is no, my lord, material against my lord father and mother-in-law. Not a, my lord, single witness, my lord, say anything about these two persons.
Today, I scan copy of LCR received, but I have not gone for the LCR.
Conviction term was for life.
No,
For
10 years to husband, my lord, and 8 years to in-laws, my lord.
so presumption was there. That is
Only ground of presumption that she died in the house of husband.
This matters 304B. This is the presumption can be taken as per law only. That's
Now,
most probably presumption.
now, my lord, the Honorable Supreme Court said, my lord, very recent judgment, my lord.
However, the presumption is there. In some cases, there are some presumption 113, 113. That is presumption. Now most probably changed by the new act. So maybe I don't know whether there is any allegation. Yes, sir, what could you want any time?
Yes, my lord. Some short date, any short date, my lord. On 12/8, my lord.
So all your petitions are behind the bus?
Yes, my lord.
Since when?
Since my lord, March, my lord, 7 March, my lord,
7 March of 2024.
2024.
I guess you want to say contradiction.
Almost 5 months.
12, wait, 12 or 14.
12 wait.
12 or 14 anyway.
12 or 14 is Thursday. Yes?
My lord, 13 will be better, my lord. Non-Muslim day, my lord.
13 is the
13.
What
13
day?
August.
Tuesday.
Tuesday, my lord.
Okay, what happened?
Yes, ma'am.
Additional support. We will try.
Lost.
This I is for?
I is for delay condemnation, Lordship. 30 days delay, Lordship.
So, Mr. Uddin, you are also appealing?
Yes, madam. We may condone, madam, 30 days. So I
How many? 30 days?
30 days, Lordship.
On
State,
merit,
please state.
matter may be heard on merit.
State. 30 days condemnation can it be condoned? Hi, Mr.
Emma Hussain.
Emma Hussain, Dilanet Computer. And also heard Mr. Anupti Dilanet Computer on behalf of and Mr. Report Dilanet Division. Next one, this is an application in section 5 of the limitation to condemn the delay of 30 days in filing the referring the criminal revision petition against the impugned order dated 15/12/2023 passed by Learned PMFG Kokrachar in with case number 89 of 2023, whereby petition number 183 of 2023 dated 14/11/2023 was dismissed. Yes, Hussein, what is the ground of delay you have mentioned? Where it
Lordship, medical ground, paragraph 2, I have stated, Lordship.
Paragraph 2.
Lordship.
Submitted in that the petitioner was suffering from serious liver disease at the time of at the time of passing the order, and he was under treatment at Guwahati and Hyderabad. And at the same time, he also had to take care of his old ailing mother, and for which there was some delay in preparing the connected revision petition, and accordingly prayed to conduct consultative. Mr. Jain further submitted that there is no intentional license or negligence on the part of the petitioner, filed or preferred the petition Mr. Bottom PP submitted to the state health office in following the delay of 30 days. And it came that Mr. Dilan counted for the respondent. He has no objection if the delay is condoned and the matter is finally heard. Next one, considering the submission made by the learning council for both sides, and also considering the grounds of delay mentioned in para 2 of the petition, I find it proper to allow control the delay of practical report allowable. So, registry with filing the number, secretary is according to the register the case. Okay, your petition is gone.
Lordship, direction may be given to number the revision petition, and then a date may be fixed. Also.
Date I cannot.
Date cannot.
I have already. Date cannot.
Este puxa ni te. 4 টাকা 8,000 টাকা